Supplemental
Beg,
list
beg,
item number
beg,
1.
beg pardon, your lordship. On urgent matter of court number 7, I have filed a miscase for interim mail on the ground of illness of the father of the appellant. Today at 9 a.m., the father had died. I pray, my lord, my senior may be take instruction whether here, Jajpur.
Mr. Interim bill
On the ground of illness ground रे file करथिली interim bail. Today at 9 a.m. he died, man.
But you have to file an affidavit and serve a copy so that you cannot make an oral submission and we'll ask him to obtain insurance. File an affidavit. If you are sure by your advocate's clerk or the party may come and file so that.
Party, my lord, it is not possible.
It's up to you.
By,
It is not over within one day. It will be a 12-13 days affair. So you may not join today, but you may go tomorrow. But file an affidavit.
my lord.
Yes.
Supplemental list item number 1.
Yes. Who is the investigating officer of the case? Come. So yesterday when the matter was taken up, we pointed out that the status report which was filed on 13/1/2024 by the IIC Banki police station, wherein it is mentioned that the rescued minor girl Lakshmi Priya Parida was handed over to her parents on 8/1/2024, and since that day she's been staying with her parents happily. The IIC said that it is asked for your instruction. She has written it and filed the status report. Whether it is a correct statement of the IIC? Are you following what we say?
Sir.
Huh? Whether you have instructed to the IIC, because you are the investigating officer.
Sir.
You told the IIC that the minor girl was handed over to her parents on 8/1/24, and since that day she is staying with her parents happily. That means this report was filed 5 days thereafter.
Sir.
And he said yesterday to us that it was mentioned as per the instruction of the investigating officer. Whether the statement which was made by your IAC is a correct statement or not.
Sir.
Correct statement.
Sir.
So whether the if it is a correct statement according to you, you have given to the IAC, and accordingly IAC has mentioned it. Now it is to be seen that whether your statement to the IAC was correct or not. The report has come, and the affidavit has been filed by the parents of the victim girl that on 8/1/2024, the victim girl was not handed over to them. She is not in their company. And we called for a report also from the London SDGM Banki, where the case is pending, along with the 164 CRPC statement. And in the 164 CRPC statement, we find that even though the victim expressed her desire to stay in the company of her parents, but the SDGM writes that the parents denied to take the minor victim girl. And requisition was given to the coordinator Open Shelter Bosundara Bidanasi Katak for giving shelter to the minor victim girl, and she was left in Bosundara on 18/1/2024, and that was the intimation which was given by you to the court.
Sir.
So you are making one statement before the IAC that on 8th, the victim has been handed over to her parents. She is living happily. You are submitting a report before the SDGM that the victim girl is now staying at Vasundhara Bidanasi Katak, and the affidavit which has been filed by the the report, the affidavit which has been filed by the IAC yesterday, it indicates that the victim girl was handed over to the cousin, one of her cousin, and he said that I will manage. And so, how did you hand over the victim to a third person if the parents expressed their unwillingness? How it was given to a cousin brother?
Sir.
On what basis? And why you told the IAC that she has been handed over to her parents and living happily with her parents?
जेहेतु सर तांकर जो दादा सर तांको बापा माँ सांगरे थिले कोर्ट रे से तांको बापा माँ सर मु बहुत बुझेली सर से किंतु नेबा पई सर बहुत चेष्टा कली सर तांको बुझेली तांको
आपणकर कोर्ट जेतेबेले कोर्ट रे विक्टिम जेतेबेले कहिले विक्टिम रो स्टेटमेंट कोर्ट रे होची मु मो बापा मां को पाखरे रहिबाकू चाहूची
सर
एया ना नहीं
सर
you must be present in court at that time,
sir.
because on your prayer 164 CRPC statement must have been recorded. There is no other way to record that. So you are aware that what the victim stated. Now when you find that the parents are unwilling to take the victim with them,
sir.
Right? Whether it was not your duty to bring it to the notice of the court so that the court would have made necessary arrangement, sending the victim to appropriate place for short stay.
Sir.
How did you hand over on your own to a third person? Who are you? You are just the investigating officer of the case. The victim will remain. If you would have major, matter is different. Since she is a minor, she is expressing her desire to stay in the company of her parents. The parents are not willing. It is to be brought to the notice of the court. The court will make necessary arrangement. The court would have directed the CWC to keep in appropriate short stay home. How did you hand over to a third person? And why, if you have handed over the purse to a third person, you have no personal acquaintance with that person? Did you bring it to the notice of the court that these things has happened? Parents were not willing. That's why this situation has come, and I handed over the victim. Suppose something would have happened with the victim, who would have been responsible for that? That is one thing. And number two, that how did you make a false statement in court through your IIC? That is why we asked whether it is the statement of the IIC or in fact you said so. That is why he has mentioned it in your status report. And you said that yes, you have intimated. So whatever you have stated to your IIC is a false statement, and accordingly, false statement has come to the court. Because on that day when the matter was taken up, the Land Council for the petitioner specifically stated that, sir, a false statement has been made. The child, the minor girl, has not been handed over to her parents. She has been given to the accused. She made a statement. He made a statement on that day. So we are proposing to initiate a contempt proceeding against you.
I apologize for my mistake, Lord.
File an affidavit, whatever you want to do. And we are calling for the whether your clients are ready and willing to take the girl. Yes.
Not LRC.
No. Then let us stay.
Now at Basundhara.
Huh?
Basundhara.
No, that's why we are asking him. File an affidavit, will close the process. In pursuance of the order dated 29/1/2024, the inspector in charge of Banki police station, namely Swanso, and the Swanso, the investigating officer of Banki PS case number 325 of 2023, is present. When the (164) CRPC statement of the victim, the report submitted by the Learning SDGM Banki, the status report dated 13/1/2024, filed by the IIC Banki police station. So also the affidavits filed by the parents of the victim were pointed out to the investigating officer in view of the contradictory statements appearing therein. The investigating officer begged unconditional apology and file an affidavit to that effect we are mentioning, and submitting that and stated that such thing will not happen in future. We put a pertinent question, no, since in the 164 CRPC statement, the victim stated that she is ready and willing to stay in the company of her parents, we put a pertinent question to the Learning Council for the petitioner as to whether the parents of the victim are ready and willing to accept the victim to stay in their company or not, comma. The Learning Council on instruction submitted that the parents are not willing to keep the victim with them. It appears from the report submitted by the Learned SDGM Banki that the victim girl is now staying at Basundhara, Bidanasi, Cuttack. in view of the statement made by the Land and Counsel for the petitioner and after hearing the Land and Counsel for the state, we dispose of this WPCRL with observation that the victim shall continue to stay at Basundhara Bidanasi Cutter and the CWC, I think they have filed something yesterday that was brought to our notice. That CWC, that child, they have stated something yesterday. In our that is there. Yes, madam. এই কালিটা দেখি କାଲି ଗୋଟେ CWC ର ଗୋଟେ ଥିଲା ତା ଦେହରେ annex କରିକି ଦେଇଥିଲେ ସେ affidavit ରେ। No, not there. No, she does it nine. Only the extraordinary. May I send the report, my lord? Yes. I want to buy it only. I'm doing it. So not left. Annex ignoration. How the victim stayed there? Who has sent the victim to Vasundhara? My SDM order is there. আমি जो extra tower ଦେଇଛୁ ନା ଏମାନେ ପଠେଇଛି ଆଇ ଅର ଇୟର ଆପଣ admission Vasundhara. They directly handed over to Vasundhara. And the intimation given to the SDM. That is at page 12, my lord. No, this is not the letter. Right. As per the order of the chairperson, Child Welfare Committee, comma, Odisha, dated 19/1/2024, passed in case number 030/2024. The coordinator, Open Shelter Vasundhara Katak, has been authorized to keep the victim girl at Vasundhara. And we are told that the girl is staying there. Let the victim girl stay in Vasundhara Katak, and the chairperson, Child Welfare Committee shall look into the welfare of the child and see that she gets proper education, fooding, and all kinds of health facilities. A free copy of the order be handed over to the Land Council for the state, which will be communicated to the chairperson, so and so also the coordinator, Open Shelter Vasundhara Katak, for compliance.
Let's be a copy of the CW copy.
Yeah.
The CW copy may make.
Give the copy.
ଏ କଣ କରିବେ ତାକୁ ତ ଯାହାକୁ ଦବା କଥା ନଉନାହାନ୍ତି କପିଟା ନେଇ କଣ କରିବେ?
We have not seen such type of parents. 14 years girl, the girl is ready and willing to go to the parents, and the parents are not willing to keep the girl. And you are coming to the High Court to take the custody of the child. Yes.
Need a common minute.
It's disposed of.
I'll file on.
Just file that affidavit and it. This personal appearance is dispensed cases. Acha, we will file an affidavit that way.
Court number 7 matter. Court
Hmm.
number 7. Matter related to sufficient act auction matter.
Hmm.
Create tomorrow. Ma'am.
File your memo.
Auction.
May I please? My lord, court number 7, listed today, item 11, and auction is urgency is that auction is fixed to today, my lord.
Hmm.
So I pray let the matter be taken up if possible.
Such matters are not maintainable here. Why are
That
you mentioning you? Move the appropriate court. There are number of decisions of the Honorable Supreme Court that the appropriate alternative forum is available. So, yes.
Quickly list item number 8.
Is it 8 or 9, man?
Hmm?
It is my lord. Yesterday he was not served the copy. We received the copy.
Blood, is it item number 8 or 9?
It's item number 8, Mr. Balakrishna Roy.
Uh, also your 16 also is your last time 25.
Hmm. What is this WPCRL for?
My lord, a minor girl being kidnapped.
Hmm.
And lordship kindly have a glance to his petition page para 9, your lordship.
Hmm.
Unknown person kidnapped. He has said that police has knowledge about the kidnap. That is why it is coming under the habeas.
But the Learning Council is not appearing.
Yesterday he was there.
Yesterday it was there.
He was there, and he served the copy yesterday to us.
Oh, that
Yes.
somebody was appearing through virtual.
Virtual.
So if copy you have received,
Yes,
you
we have
obtain
received.
instruction better. Okay.
My lord.
So, we do not know whether you correctly
Actually, CRL LMP should be filed in action of police.
uh,
In action of police, illegal detention is not there, man.
no, but the prayer is to rescue the minor girl.
My lord.
So that prayer is there. So the other part may be the
Right.
different, but
I will take instruction.
none appears for the petitioner. The Learning Council for the state submits that he has received the copy of the writ petition and he may be given some time to obtain instruction. As per the order dated 16/1/2024. Put up this matter. So let it come on 26th. You are getting that. Put up this matter in the week commencing from 26th February 2024. Yes.
Item 9.
Lord, I am appearing to virtual mode, my lord. This is a petition for production of the petition, the person's name in the petition, and your lordship had directed to get the instruction to the state. And yesterday you listed, but by mistake I could not remain present. But here today I have taken instruction that the person named in the petition, they have been rescued and they have reached their respective villages. They have reached today into the villages.
Yes, Mr. Mishra, that is also the letter of the district
Yes.
labor officer.
One thing, my lord, they were saying that they have not received their wages, if possible, through the counterpart agency, if possible, my lord.
That
Then if
cannot
I
be
said,
actually
I said only it is what they said. I'm conveying to your lordship. If possible,
No,
if
it's
not paid, that wages may be cleared.
it is limited. You have got the relief, Mr.
No,
Mishra.
no. There is no doubt with it, my lord. Though there were some of them are ill and they have
It's a
hospital.
really commendable thing which you have done, but because we know that how sometimes the migrant workers
Yes,
were. So it's really we appreciate that you brought to the notice of this court and the persons have now been rescued.
yes, they have reached the village, excepting the 3-4 persons are hospitalized because of the bad treatment they had received.
Right, right.
But in fact, they have already reached
Okay.
the village.
All right. I heard Mr. H.S. Misra, learned advocate through virtual mode. The Learned Council for the state has produced the later dated 29/1/2024 of the district labor officer Suvarnapur, wherein it is mentioned that all the migrants workers have been rescued. The later is taken on record. Mr. H.S. Mishra, Land Council, on instruction submitted that the contents of the letter are correct in view of the submission made by the Land Council for the petitioner and the letter produced before us by the Land Council for the state. No further order is required to be passed. Accordingly, the WPCRL is disposed of.
Man, obliged.
Item 10.
It was hard earlier or first time?
No, first time. The report was called for regarding the appellant number 2. Whereabout, my lord? The one has already died,
Yeah, there are two appellants.
my lord.
So, who is dead?
One.
And what about two?
He is now Alim, my lord.
Ali.
I submitted reports.
This is the report regarding death of that appellant number 1. But you are further required to
Submitted now.
have you submitted? এটা হচ্ছে কেবଳ ପିଚି ନାୟକର ଆପଣ ପାଖରେ ଅଛି ମାୟା ସେଇଟା କେମିତି ଦେଲେନି ମାୟା ସେଇଟା ମତେ ଦେଇନି এটা ବାହାର କର previous order. As per the order dated 16/1/2024, the Land Council for the state has produced the letter dated 29/1/2024 of the IAC of Tangi Police Station, wherein it is mentioned that the appellant number 2, Mayadhar Naik, is staying at Jai Singh under Punjeri Police Station, Punjeri Gram Panchayat, which is family members. The same was ascertained from the local gentries as well as local sarpanch. Later is taken on record. So far as one is concerned, it has already abated because of the previous order. So now you confine your argument only for this appellant number 2.
Number 2. Yeah. Appellant convicted under section 302 and 34 IPC. Sentenced to undergo RIP.
So come to the first information report.
That's page number 20. Page number 20. Running page 20.
Please.
ନିବେଦନର କାରଣ ଏହିକି ଯେ ଆମ୍ଭେ ଦରଖାସ୍ତକାରୀ ଶ୍ରୀ ଜନକ ସାସମଲ ପିତା ବାଞ୍ଛାନିଧି ସାସମଲ ପାରିଓରଡ ଥାନା
Sasmal is PW.
PW 10.
Okay.
ଅଦ୍ୟତା 23/6/2002 ରିଖ ଦିବା 9 ଘଟିକା ସମୟରେ ମୁଁ ମୋର ମାମୁ ପୁଅ ଭାଇ ପାରିଓରଡ ଗ୍ରାମର ବାସିନ୍ଦା ଶ୍ରୀ ଦାଶରଥୀ ସିଠ ଏବଂ ଭାସ୍କର ସିଠ ଉଭୟଙ୍କ ସହିତ ମିଶି ତାଙ୍କର ଟୁଟୁମ୍ବର ପଲ୍ଲୀ ମୌଜାରେ ଥିବା ଚାଷ ଜମିକୁ ହଳ କରିବା ପାଇଁ ଯାଇଥିବା ଅବସ୍ଥାରେ ଉକ୍ତ ଜମିର ମାପ ଚିହ୍ନଟ ପଥରକୁ କେନ୍ଦ୍ର କରି ପାରିଓରଡ
Dasarathi Sitha is the deceased. Okay. And Bhaskara Shetty is one of the
Bhaskara Shetty is the injured witness and the
is
brother of the
PW?
PW 13.
Okay.
Brother of the deceased.
And Bhaskar Shetty
Brother of the deceased.
ସେଟା କହୁଛନ୍ତି ଦାଶରଥୀ ସେଠ ଏବଂ ଭାସ୍କର ସେଠ ଉଭୟଙ୍କର ନାଇଁ ଉଭୟଙ୍କ ପିତା ଲେଖା ହଉନି ଖାଲି ଲେଖା ହଉଛି ଉଭୟ so they are brothers.
They are two brothers.
Okay.
କେନ୍ଦ୍ର କରି ପାରିଓଡ ଗ୍ରାମର ବିଚି ନାୟକ ପିତା ନାରାୟଣ ନାୟକ ରାଜ ନାୟକ ପିତା ନାରାୟଣ ନାୟକ ମାୟାଧର ନାୟକ
Bichi Naik is the
ବିଚି
appellant
ନାୟକ is
who
the
is dead.
dead.
A1 dead. Okay. This Rajo Naik is not an accused.
Not an accused. Narayana Naik Pita Mayadhara Naik.
Mayadhara Naik is the appellant number 2. Okay. Yes. Apparti Naik is also not an accused.
Not an.
ମିଶି
ପଦ୍ମ ନାୟକ ପ୍ରଭୃତି ମିଶି ହଠାତ୍ ହାତରେ ଠେଙ୍ଗା କଟୁରୀ ଏବଂ ଗୁପ୍ତି ଇତ୍ୟାଦି ଧରି ଦାସ ସିଠକୁ ସଚ କରିଥିଲେ। ସମସ୍ତେ ମିଶି ତଣ୍ଟି ଚିପି ବିଧା ଜାବୁଡା ମୁଥ ମାରି ଆଘାତ କରିଥିଲେ। ତାଙ୍କୁ ଜୀବନରେ ମାରିବା ଉଦ୍ଦେଶ୍ୟ ଥିବା ଆସାମୀ ବିଚି ନାୟକ ହାତରେ ଧରିଥିବା କଟୁରୀ ଦ୍ୱାରା ଦାସ ସିଠ କଟୁରୀରେ ହାଣି ଦେଇଥିଲେ। ଏଟା ହଉଛି ବିଚି ନାୟକର କଟୁରୀ। ଅପର୍ତ୍ତି ନାୟକ ମଧ୍ୟ ହାତରେ ଗୁପ୍ତି ଧରି ଆକ୍ରମଣ କରିଥିଲା। ଦାସ ସିଠର ମୁଣ୍ଡ ହାଣି ହୋଇ ଅତ୍ୟଧିକ ରକ୍ତସ୍ରାବ ହେବାରୁ ସେ ସେହି ଜାଗାରେ ତଳେ ପଡି ଯାଇଥିଲା। ଭାଇ ଭାସ୍କର ସିଠ ଛଡାଛଡି କରିବାରୁ ତାକୁ ମଧ୍ୟ ଆସାମୀମାନେ ମିଳିମିଶି ଆଘାତ କରିଥିଲେ। ମୁଁ ଏବଂ ସାକ୍ଷୀମାନେ ମିଶି ଦାସକୁ ଚିକିତ୍ସା ନିମନ୍ତେ ଟାଙ୍ଗୀ ସରକାରୀ ଡାକ୍ତରଖାନାକୁ ନେଇଥିଲୁ। ତାର ସ୍ୱାସ୍ଥ୍ୟର ଅବସ୍ଥାରେ ଅବନତି ଘଟିବାରୁ ନାକ କାନ ଏବଂ ପାଟିରୁ ରକ୍ତସ୍ରାବ ହେବାରୁ ଏପରିକି ଚେତାଶୂନ୍ୟ ହୋଇ ପଡିବାରୁ ଦାସ ସିଠଙ୍କୁ ସଙ୍ଗେ ସଙ୍ଗେ ଆମ୍ବୁଲାନ୍ସ ଯୋଗେ ତାର ଭାଇ ଏବଂ ମା କଟକ ଡାକ୍ତରଖାନାକୁ ନେଇ ପଳାଇଥିଲେ। ଆସାମୀମାନେ ଅତ୍ୟନ୍ତ ଦୁର୍ଦାନ୍ତ ଲୋକ ଅଟନ୍ତି। କୌଣସି ବ୍ୟକ୍ତି ଆସାମୀ ବିରୁଦ୍ଧରେ କ୍ଷମା ଦେଲେ ସମସ୍ତଙ୍କୁ ଜୀବନରେ ମାରିବା ପାଇଁ ଧମକ ଦେଇଥିଲେ। FIR
As for the FIR version, so far as the deceased is concerned, specific overt act has been attributed against appellant number 1 who have assaulted by means of a koturi and one Apparti by Gupti. Others omnibus allegation that they have assaulted. And
Well, he is not the eyewitness to the
who is not an
the present.
we'll come to that. And so far as the injured
Injured witness PW 13.
PW 13 is concerned,
Let's see.
ତାକୁ ସେ କହୁଛି
PW 13 page
ଛଡାଛଡି କରିବାରୁ ଆସାମୀ ମାନେ ମିଶି ଆଘାତ କରିଥିଲା। ଆଚ୍ଛା, PW 13 କୁ ମଧ୍ୟ ଯେ ଗୋଟେ ଜେନେରାଲ ଆଲିଗେସନ ସମସ୍ତେ ବାଡେଇଥିଲ। So in this case the PW 13 is an eyewitness, sole eyewitness.
Say PW 17 is the
7
eyewitness are already the Lawrence trial court has a
some
finding
eyewitness as
that
hostile manner,
Okay.
and one eyewitness is just post occurrence.
PW 7 disbelieved.
PW 17 disbelieved.
So what you say, another eyewitness is there? Mane, just post occurrence witness.
There's
immediate
17 madam.
PW 17.
17
He has been disbelieved.
Disbelief madam.
Okay.
And now the only PW 13 madam.
Only
Okay.
PW
PW 13 means and the injured eyewitness, right?
And here in this case
doctor
also
has
the doctor,
has not been examined.
because
Doctor
he,
means
the postmortem conducted by the postmortem, because he left the service and that's why he could not.
PM not examined. And what about the medical examination report of PW 13?
That has been doctor has been examined. Madam.
Who is the doctor?
That is Dr.
Dr.
Myler
PW1.
1.
PW1 doctor examine PW 13.
And PW 2 is the Myler seizure witness to the weapon.
No, we find that for the assault on PW 13, there is no such conviction because charge was framed under section 323 for that purpose. The charge is at page 21. It is mentioned that you voluntarily caused to assault to Bhaskara set means PW 13.
PW 3, PW 4, and PW 5 Myler hostile.
No, Mr. Just
Myler.
Even though he was the accused persons were charged under section 323 for assaulting PW 13, that charge has been disbelieved or he has not taken into account because he has not been found guilty under section 323.
No, Lordship, only under section 302.
अरे 302 तो ହେଇଛି ମୁଁ 323 କଥା ପଚାରୁଛି
323 ରେ ହେଇନି conviction.
କାଇଁ ଆକ୍ୟୁଟାଲ ହେଲା ନା ସେ ବିଷୟରେ କିଛି ଡିସ୍କସନ କରନି ନା କଣ?
Discussion ହେଇନି. PW 13 and to convict is the PW 323 page number 12. Since the accused Mayadhar has been convicted under section 302 IPC, I do not proceed separately against him for voluntary cause hurt to the PW 13.
Okay, that was the reason given. Acha. Okay, so now you come to that, first see that report, medical report of that PW 13, which has been proved by PW1. At page 40, PW1. So as it appears, he has
two injuries. One lacerated and one abrasion.
The injury were
Both
simple
the
in
injuries
nature.
are simple in nature. Okay.
Caused by
and the date of examination is dated 23/6/2002. All right. Now you come to the eyewitness, that is PW 13, which is at page
66 page. I know the accused persons. The informant Janak Sasmal is my cousin brother. The occurrence took place on 23/6/2002 at about 9 a.m. in my land, the land situated in Mauja, Kutumbarapalli. Both myself and my brother Dasarathi had been to our land and we are working there. The land of Padma Nayak is situated adjacent
Dasarathi means the deceased.
Dasarathi is deceased.
Yes.
To our land. Aparti Nayak is the son of Padma Nayak and these accused persons are his nephew. While we were working in our land, Aparti Nayak accused Bichi Nayak and his wife came and objected, stating that we should get the land demarcated first. The land was previously demarcated thrice. Still, we went to the other Kiari and worked there. Again at 9:30 a.m., both the accused persons came and challenged us. I was then sitting near a bamboo bush adjacent to the ridge of my land. My brother Dasarathi was working in the land along with the laborers. Pichi was holding a katuri. Seeing them, I got up and inquiry as to what happened. Aparti was holding a gupti. Accused Bichi suddenly caught hold of my left hand and Mayadhara gave a fist blow on my face over the lip and then dealt a blow by the Gupti.
Just a
The
minute. Mayadhar means
Mayadhar,
appellant number 2.
appellant number
Gave
2.
fist blows
Fist
on my
blow.
face
Let's
over the lips and then dealt a blow by Gupti
the
on the backside of my
backside
head.
of the
Acha.
head.
Okay. And gave a push saying to take me to
Take me on the backside of my head and push me,
murder
take
me
me.
like
Buttiya here,
Ramo
to
Sita.
murder me, Ramo Sita.
Okay. Then
Accused Bichi, then abusing him in obscene word, asked by my brother to take out the earth which were caught from the ridge of the Kiari, where we were working previously adjacent to their land. Then both the accused persons caught hold my brother, and at that time accused Aparti took out the Gupti metal portion and threatened me. Thereafter, Aparti rushed towards my brother, and all three of them put my brother on the land, and then both the accused Bichi and Mayadhara assaulted my brother by means of a katuri and a spade. On his head, my brother shouted, Marigali, Marigali. Immediately, I called my uncle Krishna Chandra Sitha, who was working on his land, which is situated about 3 kiaris away from our land. Mayadhara called Aparti to leave the place, saying Dasarathi was dead. At that time, the two laborers, Dilip Sahu and Sharat Pradhana, had fled from the spot towards the villagers. Dilip Sahu and Sharat Pradhan, uh, only Sharat Pradhan was examined, PW 12. The hostile. From the spot towards the village out of fear. When my uncle reached the spot, my brother asked for water, and I called Bisika, who came from her land and administered water. PW4 hostile. I then asked my uncle to go to the village, call our family members and other to take my brother, my mother, my brother, Biranchi Sitha, Rabina Sitha, Trinatha Sitha, and Patiya Sahu came to the spot, and we brought our brother to Tangi Hospital in an auto belonging to Bauno Pradhan. My brother was then shifted to Katak Medical on the next day during night. My brother expired. My another brother, Tufana, also.
there is nothing about the recording of any dying declaration or oral dying. Nothing. Yes. Yes, please place the cross examination.
I was reading cross examination. I was reading law after graduation. There was a long distance dispute between the accused persons and us relating to the ridge between our land. On the date of occurrence in the morning, the accused persons come and challenged as to why we cut the ridge. They told us to cut the ridge only after the demarcation. At that time, many persons were working on their land near about our land. By then, I was sitting at a distance at 10 cubits from land where my brother was working. I saw fast Bichi coming, abusing my brother, following by other accused persons. He came to the land where my brother was working, passing through me. He did not abuse me during my passing through. My brother did not try to run away, seeing the accused persons. Dilipio and Sarata also did not run away, seeing the accused persons. Only after all the accused persons arrived at the spot, Bichi assaulted my brother by means of a panchana stick which was lying there on the ridge. By then, the buffaloes were unwake. The spade Cody were also lying on the land. I did not come to the spot to rescue my brother out of fear. I did not try to run away from the place where I was sitting. I sustained injury due to assault on my lips and on the back side of my head. One of my teeth of a lower jaw, but second through the tooth was not broken. All the occurrence took place on the land itself, and I saw at a distance of about 5 cubits when my brother was assaulted. 3 blows were given each by the spade and a katuri on the head of my brothers about 2 inch, uh, 2 inch above the right ear. He had also sustained bleeding injury on the backside of his head. He had also bleeding injury on the backside of a neck and a cut injury on the right side cheek. The entire occurrence of assault was over with 5 minutes. My brother was wearing a lungi and was giving a napkin. The lungi was of blue color and the napkin was a red color. Both the lungi and the napkin was stained with blood. The spade, katuri, and a panchana stick were lying at the spot, having marks of blood. We brought those articles with us. The auto was brought to the file about 400 to 500 yards away from the spot. The accused Bichi also bleeding injury on his right arm. The accused persons arrived at the PS at the hospital prior to us. I saw the bandage on the head of Bichi only at the
Is it a
hospital.
counter case? Case
Yes,
counter case?
yes, Lordship, counter.
What happened in the counter case?
Counter case has not been charge sheeted.
Okay. Have you proved any documents of that counter case?
Yes, mark as Exhibit A is the FIR.
Just a minute. Counter case wala exhibit,
A.
that is the FIR.
FIR
Yeah.
GR case number 520 of 2002.
What happened in that counter case? Whether charge sheet submitted or final report? And any medical examination report proof of any of the appellants?
No,
Because from
final
these
form-
4 to 5 lines,
final form of the
no, it's all right. But from these 4 to 5 lines, it also appears that he had been to this appellant number 1,
yes,
had been to the hospital.
yes,
He had gone to police station, then to the hospital. He had a bandage on the head, and doctor told that Vichy would survive. Vichy means appellant number 1 would survive, and he was admitted, and my brother was shifted to Cuttack, right?
yes.
So, any doctor examined to prove any injury report?
Injury report or
Yes.
injury report is the Bichina
Injury report of the appellant number 1.
Lordship, Exhibit D by 1.
Kohunathi mo-
Certified copy of the final opinion of injury.
Exhibit D by 1 is the injury report.
Injury report, opinion, final opinion of the injury.
All right, we'll see that injury
Certified
report
copy of the final opinion.
of A1.
Exhibit C is the certified copy of injury report. Exhibit C is the defense.
C and D, Y1.
C.
All right, we'll go to that. Please continue that. This cross-examination which you are placing. Come to paragraph number 4.
Paragraph 4.
Yes.
I was examined by police at the PS on the night of the 25th. It is not a fact that I did not state to the IO that Bichi Naik assaulted my brother by a koturi and then Mayadhara by the spade on the back side of my brother's head when he was put down on the land, that when I reached near my brother, he asked for water. It is not a fact that I have stated to the IO that when Oporti and Mayadhara chased me to kill, I ran towards the land of Padmanabha, that after running to a distance when turned back, I saw Bichi Naik had put my brother on the land and was assaulting on his head by snatching the spade from my brother. That seeing my uncle from distance, I called me, and when I came back to my brother's,
These contradictions have been proved through the IO.
IO.
अरे एटा पचराला से not a fact कहला ना माने IO की PW केते
PW 16
PW 16 जरिया रे एटा प्रमाण हिची
PW 13 नो मिला
हां PW 13 नो contradiction टा जोटा
ना
पचर तले कहीं सेटा नहीं तमले
इटा पर्टिकुलर से जो लाइन टा
हां छी तो ये
हां पारा
come to
79
paragraph
पेज
10.
79 वाला पारा
Please come to
10.
page 79.
पेज 10 पारा 10 में
79 para
10 में
PW 13. Bhaskar Sitha has not stated to me that Bichi Naik assaulted his brother by koturi and then Mayadhar by the spade on the backside of his brother's head. He has stated to me that when Aparti and Mayadhar chased him to kill, he ran to the land of the Padmanabha and after
Mic properly. We are unable to hear you. What you are saying.
PW 13. Bhaskar Sitha has not stated to me that Bichi Naik assaulted his brother by a koturi and then Mayadhara by the spade on the backside of his brother's head. He has stated to me that when Oporti and Mayadhara chased him to kill, he ran to land of Padmanabha and after running to distance when he turned back, so Bichi Naik and put this brother on the land and assaulting on his head by snatching the spade from his brother. That's it. I would evidence.
So, यार statement जा अच्छी ये पुलिस प्रकार स्टेटमेंट थिला जे अपर्ती आ मायाधर मते गोडेइले मु पद्मनाभर जमी आड़कू दौड़िली आउ किछि बाट गला परे मु पछुकू चाहिली आउ सेतेबेले देखिली बिची नायक माने अपेलेंट नंबर 1 had put my brother on the land मो भाई को ता जमी ऊपर पकई दीची and assaulting on his head by snatching the spade from my brother. But and at seeing my uncle from the distance, I called me and I took and so on. So let us see that 161 statement, what he has stated. Hey, bar karo tera. 161 of PW 13. Let's see what he has stated. Bhaskar Sitha. Mayadhara. ଭାସ୍କର ସେଠୀ
ଭାସ୍କର
ମାନ
ଶିଖ
ହଉଛି ଭାସ୍କର ସେଠୀ। ଆଚ୍ଛା, ହଁ, ଭାସ୍କର ସେଠୀର ଷ୍ଟେଟମେଣ୍ଟ ହେଲା 23/6/2002,
occurrence
that is the date of occurrence. ଏଇଟା ଦିଅ 23/6/2002 ଦିନ ସକାଳ 5:30 ସମୟରେ ମୋର ଭାଇ ଦାଶରଥୀ ମାନେ ଡିସିଜ୍ଡ ଆମର ହଣ୍ଡା ହଳ ଲଙ୍ଗଳ ଓ କୁରୁଡି ଆଦି ନେଇ ଚାଷ ଓ ହିଡ଼ କାମ କରିବା ପାଇଁ ଆମର କୁଟୁମ୍ବର ପଲ୍ଲୀ ବିଲ ଆଡକୁ ଗଲେ। ଆଚ୍ଛା, ତାଙ୍କ ପଛେ ପଛେ 6:30 ବେଳକୁ ମୁଁ ଆମ ଗାଁର 2 ଜଣ ମୂଲିଆ ଦିলীପ ସାହୁ ଓ ଶରତ ପ୍ରଧାନକୁ ସାଙ୍ଗରେ ନେଇ କୋଡ଼ି ବାଉଁଶ ଝୁଡ଼ି ଆଦି ଧରି କୁଟୁମ୍ବପଲ୍ଲୀ ସ୍ଥିତ ବିଲକୁ ଗଲୁ। ଠିକ, ମୋ ଭାଇ ଓ ମୁଁ 2 ମୂଲିଆ ମିଶି ଆମ ବିଲରେ ହଳ ଓ ବିଲରେ ହିଡ଼ କାମ କରୁଥିଲା ବେଳେ ଅପର୍ତ୍ତି ନାୟକ ବିଚି ନାୟକ ହେଲା ଦିଟା ମରିଯାଇଛି। ଆଚ୍ଛା, ଓ ବିଚି ନାୟକର ସ୍ତ୍ରୀ ଆସି ଆମ ବିଲ ପାଖରେ ପହଞ୍ଚିଲେ। ଅପର୍ତ୍ତି ହାତରେ ଗୋଟିଏ ଗୁପ୍ତି ଧରିଥିଲା। ବିଚି ନାୟକର ସ୍ତ୍ରୀ ହାତରେ ଗୋଟେ କଟୁରୀ ଧରିଥିଲା। ଅପର୍ତ୍ତି କହିଲା, ଦାସ କାହିଁକି ବିଲ ହିଡ଼ ଗଡ଼ାଉଛୁ? ମାପ ଚୁପ ପରେ ହିଡ଼ ଦେବ। ସେମାନଙ୍କର କଥା ରଖି ଆମେ ଆମର ଉତ୍ତର ପଟ ପଦ୍ମନାୟକର ବିଲ ଲାଗିଥିବା ହିଡ଼କୁ ଛାଡ଼ି ଅନ୍ୟ ହିଡ଼ କାମ କଲୁ। ସେମାନେ ମଧ୍ୟ ତାଙ୍କ ଘରକୁ ଫେରିଗଲେ। ପ୍ରାୟ ଦିନ 9:30 ବେଳକୁ ବିଚି ନାୟକ ଏଗେନ୍ ଆପଲାଣ୍ଡ ନମ୍ବର 1 ହାତରେ ଗୋଟେ କଟୁରୀ ଧରି ଉତ୍ତ୍ୟକ୍ତ ହୋଇ ପୁଣି ଥରେ ଆମ ବିଲକୁ ଆସି ଗାଳି କରି କହିଲା, ସୁଆଣ୍ଡସୋ ଭାସ୍କର କୁଆଡ଼େ ଗଲା? ଭାସ୍କର ମିନ୍ସ ଇଏ ନିଜେ। ମୁଁ ନିକଟରେ ଥିବା ବାଉଁଶ ଗଛ ମୂଳରୁ ଉଠି ଆସି ବିଚି କଣ ହେଲା ବୋଲି ବିଚିକୁ ପଚାରିଲି, ମାନେ ଆପଲାଣ୍ଡ ନମ୍ବର 1 କୁ ପଚାରିଲି। ଦେନ୍ ଏହି ସମୟରେ ଅପର୍ତ୍ତି ନାୟକ ତାର ଗୁପ୍ତି ଧରି ଆସି ତାର ବଡ଼ ବାପା ପୁଅ ମାୟାଧର, ନାଉ ଇଟ୍ କମ୍ସ ଆପଲାଣ୍ଡ ନମ୍ବର 2, ଖାଲି ହାତରେ ସେଠାରେ ପହଞ୍ଚିଲା। So the appellant was empty handed. ବିଚି ମୋ ହାତ ଧରି ମୋଡ଼ିଲା। ମାୟାଧର କହିଲା, ସୁଆଣ୍ଡସୋକୁ ବୋଇତିଆ ନେଇ ଚାଲ, ରାମ ସେଠ ଭଳିଆ କରିଦେବା। ମାୟାଧର ମୋର ମୁହଁକୁ ବିଧାଟେ ପକେଇଲା। ଏଥିରେ ମୋର ଥୋଡ଼ି ଫାଟି ରକ୍ତ ବାହାରିଲା। ଏହାପରେ ଅପର୍ତ୍ତି ତାର ଗୁପ୍ତି ଧରି ଓ ମାୟାଧର ତା ସାଙ୍ଗରେ ଜୀବନରେ ମାରିଦେବା ପାଇଁ ଗୋଡ଼େଇଲେ। ଆଚ୍ଛା, ତାକୁ ଗୋଡ଼େଇଲେ ମାନେ ଭାସ୍କରକୁ ଗୋଡ଼େଇଲେ। ମୁଁ ଆମର ଉତ୍ତରକୁ ଥିବା ପଦ୍ମନାୟକର ବିଲ ଆଡ଼କୁ ଦୌଡ଼ିଗଲି। ଅପର୍ତ୍ତିର ଗୁପ୍ତି ବାଜି ମୋ କପାଳ ଖଣ୍ଡିଆ ହୋଇଗଲା। ମୁଁ ଖଣ୍ଡେ ଦୂରକୁ ଦୌଡ଼ି ଯାଇ ଫେରି ଚାହିଁ ଦେଖିଲି ବିଚି ନାୟକ ମୋ ଭାଇ ଦାଶରଥୀକୁ ତଳେ ପକାଇ ଦେଇଛି ଓ ଭାଇଠାରୁ ଫାଉଡ଼ା ଛଡ଼ାଇ ଭାଇର ମୁଣ୍ଡକୁ ହାଣିବାକୁ ଲାଗିଛି। ଅପର୍ତ୍ତି ଓ ମାୟାଧର ମଧ୍ୟ ସେଠାରେ ପହଞ୍ଚି ତିନିଏ ମିଶି ମୋର ଭାଇକୁ ଆକ୍ରମଣ କଲେ। ପ୍ରଥମେ ବିଚି ନାୟକ ଆମର ହଳୁଆ 5 ଜଣ ବାଡ଼ିରେ ମୋର ଭାଇ ଦାଶରଥୀକୁ ପିଟିଲା। 3 ଜଣଙ୍କର ଆକ୍ରମଣରେ ମୋର ଭାଇ ମରିଗଲି ହୋଇ ଚିତ୍କାର କଲା। ଏହି ସମୟରେ ଆମର ମୂଲିଆ ସୁଆଣ୍ଡସୋ ଭୟରେ ଗାଁ ଆଡ଼କୁ ଦୌଡ଼ି ପଳାଇଲେ। ଖଣ୍ଡେ ଦୂରରେ ମୁଁ ଆମର ସୁଆଣ୍ଡସୋକୁ ଧାଇଁ ଆସ ବୋଲି ଡାକ ପକାଇଲି। ମାୟାଧର କହିଲା, ଆସ, ଦାସ ମରିଗଲାଣି, ପଳେଇ ଆସ। ସେ 3 ଜଣ ଯାକ ଆସାମୀ ଆମ ଗାଁ ଆଡ଼କୁ पढ़ाई जीवा परे मो भाई को पाखु जे देखली भाई रो दे हाथ खंडिया खबर आई मुंड हाणी प्रबल रक्त बाहर गण गण होची एई समय कृष्णदास आसी कहले निकट रे सुआंशु बिल रे आम गाँव सुआंशु दौड़ी आसी ओके that means so far as the participation of this present appellant Mayadhar is concerned, the previous statement was that he gave fist blows on the face of PW13 and there was bleeding. Then Opporti and this appellant number 2 chased PW13 to assault. So after running to for some distance, he turned and saw that Bichi Naik, who is dead, he was assaulting the deceased. And he just took away the spade from the hands of the deceased and assaulted the deceased. And then it is stated that the Apporti and the present appellant number 2, they joined and attacked. So this is the case as per the now the postmortem report, what it indicates.
Lorraine trial court is a lordship the postmortem report.
No, postmortem report is marked as
Exhibit
Postmortem report, my lord.
exhibit
Exhibit 11.
11. Exhibit 11.
Bharkar exhibit 11. Okay.
One stitched asserted wound.
Hmm.
4, 5.
External injury होची गोटे stitched lacerated wound गोटे जोटा की right temporal parietal region रे रही.
Number 1.
That is injury number 1. Number 2 contusion on the right temporal सेठी गोटे. Number 3 left mastoid region. अच्छा. Abrasion गुड़ाक रही brown color so and so. That is
Vita multi abrasion.
Multiple abrasions होची varying so and so on the dorsum the right palm रे अछि. Left palm. Now, certainly
And there also depressed fracture also is there.
Because the cause of death has been opined
due to craniocerebral
injury, head injury जो death ହେଇଛି.
external
Injuries गुड़ाक सब antemortem in nature. So as it appears, he has received number of injuries, and those injuries are by blunt weapon. କାରଣ ସବୁ ଗୁଡାକ lacerated wound, contusion କୌଣସି sharp cutting weapon ର ଇଏ ନାହିଁ. But
so far the S77 रे जो डॉक्टर को ओपिनियन रे regarding the weapon use, my lord. The doctor opined that the injuries number 2 and 3 can be possible by MO1. MO1 is the stick. And injury number 1 cannot be possible by MO4. Koturi, my lord. And this is the report of so and so. Then, my lord, the counter case.
counter case. Spade has not been removed.
Just a minute. You, if we come to that PW 13 ର ଯୋଉଠି deceased କୁ assault start ହେଇଛି,
ଆଜ୍ଞା page 67
page 67
middle
middle ରେ ତାର ଆରମ୍ଭ ହେଇଛି then both the
Then
accused
both the
persons, ସେଇଠୁ ଆରମ୍ଭ ହେଇଛି assault.
Myra.
Then both the accused persons means who are those both the accused persons?
ମାନେ ତା ଉପରେ ହେଇଯିବା ସେ ଯୋଉ
Bichi and Mayadhara.
ବିଚି and ମାୟାଧର ତା ଉପରୁ ଯେବେ ପଢିବା
Last
ମାନେ
line
from the
is,
starting
then
of
both
the
the
accused
accused
Bichi suddenly caught hold of my left hand and Mayadhara gave a fist blow on my face over the lips and then dealt a blow on the backside of my head and gave a
All right, so it is both the appellants,
Both the
right? So both the accused caught hold of my brother, and then accused Aporthi. Aporthi is not an accused.
Not.
Took out the Gupti and threatened me.
At the time of the
Thereafter, Aporthi
Rose towards my
brother,
and
all
all
three of them
put my brother
on the land, and then both the accused
Bichi and
Madhav,
assaulted by
A1 and A2, assaulted by
means of cutlery and
spade.
So Bichi hala Koturi, ye hala spade re on the head. My brother shouted so and I called so. Now this is somehow amane ye marichi kouchanti spade re.
Yes, sir. Postmortem report has not been specific.
এই particular statement ଟା police ପାଖରେ ନାହିଁ। ଏଇ ଯୋଉଟା ଆପଣ ଦେଖେଇଛନ୍ତି ଯେ ପିଚି ଆଉ ମାୟାଧର ମାନେ ଯୋଉଟା ବର୍ତ୍ତମାନ survive କରୁଛି appellant number 2, accused Bichi and Mayadhara assaulted my brother means the deceased by means of koturi and spade on his head. Just take pause for a moment. This is the chief examination statement. Now you see the confrontation has been made in page number 69
79
no first 69
69
confrontation duty paragraph 4 re it is not a fact that I did not state to the IO that Bichi Naik assaulted my brother by means of cutlery and Mayadhar Bichi Naik hala appellant number 1 and Mayadhar by means of a spade on the back of the brother's head when he was put down on the land. Hala এইটাକୁ ବର୍ତ୍ତମାନ ତାଙ୍କୁ ପଚରା ହେଲା ସେ ମନା କଲା. Now it has been proved through the IO.
IO 79
IO ହେଲା page 79 paragraph number 9
10 man
10 eta sorry 10 PW 13 has not stated to me that Bichi Naik assaulted his brother by kotari and then Mayadhara by a spade on the backside of my brother's head. ये गोटे vital contradiction आइला. Rather तार statement कौन थिला? ता statement थिला जे मते ए दी जण गोडेइले. की गोडेइले ना अपर्थी जी accused नुहे से गोडेला एवं appellant number 2 गोडेला. गोडेला टू मु कौन कली ना पद्मनाभर जमी आड़े को दौड़िली. एटा मध्य पचराइता. It's not a fact that I have stated. तमे एई भलिया कहिছো. And after running to a distance, when I turned back, I saw Bichi Naik had put my brother on the land and assaulting on his head by snatching the spade from my brother. ତେଣୁ ଏଇ ଜିନିଷଟା କୁ ମଧ୍ୟ ପ୍ରମାଣ ହେଇଛି କୋଉଟା ସେଇ IO
and so para 5 also that is regarding the para 5 page 70 regarding the counter case now.
No, we'll go to that. IOR evidence को आसंतु बर्तमान.
Yeah, page 79.
See paragraph 10 re, he has stated to me
Well,
that Aparti and Mayadhara chased him to kill. He ran to the land of Padmanabh, and after running to a distance, when he turned back, saw Bichi Nayak had put his brother on the land and assaulting on his head by snatching the spade from his brother. Hala? So, completely two different statements. Court ro statement रहुची जे मु देखिली मो भाई को
Bichi and Mayadhara.
appellant number 1 बिची कटुरी रे मारला आउ appellant number 2 कोदाल रे मारला कोठी की मारला ना मुंडे को मारला दी जन जाक मारले प्रीवियस स्टेटमेंट होची जे मते अपरती आ मायाधर गोडेइले मु पळैली पद्मनाभर जमी आडकू किछि बाट गला परे मु जेतेबेले पछुकू बुली देखिली जे बिची नायक मो भाई को जमी रे पकई देइची एवं भाई टू कोदाल छड़ई आनी ता मुंडू को मारुची सो say and that is the reason why he communicated this matter to the informant. Informant is PW. Come to the evidence of PW.
59, page number 59. I know both the accused persons. The occurrence took place about 2 years back on a Sunday at about 9:30 am. Dasa Sitho and Bhaskara Sitho had been to their land in Tutumbarapalli, Mauja. At that time, both the accused persons and one Aparti came to the land of Dasa Sitho holding Katuri and Gupti. By the time I reached the land, the accused persons had already left the place, causing injury on the backside neck of Dasasitha, and blood was coming up his mouth. I and other brought the injured Dasasitha to Tangi Hospital, from where the mother and brother of the injured to him to Kotak Medical. The younger brother of the injured.
This one you mark, very important line. The younger brother of the injured, Bhaskar.
Yes, the younger brother injured Bhaskar asked to me.
That man is PW 13. PW 13 asked me to report about the incident before police.
Yes.
Accordingly, the FIR was drafted and the report was lost, right?
Yes.
So, whatever he has stated in the FIR, he is not an eyewitness, but on the basis of the statement of the injured
witness.
So, the first story as per the FIR, if we again come to the FIR, we'll find that what is there.
Name is not there.
So far as the assault on the deceased Dasa is concerned,
ଦାସ ଆସାମୀ ବିଚି ନାୟକ ହାତରେ ଧରିଥିବା କଟୁରୀ ଦ୍ୱାରା ଦାସ ସିଠ କଟୁରୀରେ ହାଣି ଦେଇଥିଲା।
ଆସାମୀ ବିଚି ନାୟକ ହାତରେ ଧରିଥିବା କଟୁରୀ ଦ୍ୱାରା
ଦାସ ସିଠକୁ କଟୁରୀରେ ହାଣି ଦେଇଥିଲା। ଅପର୍ତ୍ତି ନାୟକ ମଧ୍ୟ ହାତରେ ଗୁପ୍ତି ଧରି ଆକ୍ରମଣ କରିଥିଲା।
ଦାସ ସିଂର ମୁଣ୍ଡ ହାଣି ହୋଇ ଅତ୍ୟଧିକ ରକ୍ତସ୍ରାବର ସେ ସେହି ସ୍ଥାନରେ ତଳେ ପଡି ଯାଇଥିଲା। ଭାଇ ଭାସ୍କର ସିଂ ଛଡାଛଡି କରିବାରୁ ତାକୁ ମଧ୍ୟ ଆସାମୀମାନେ। So, Mr. Das, FIR होची जो दिया ହେଇची 10 PW 10 जदिओ ଦେଇची, that was as per the version of the injured. Injured means PW 13. So your initial case is also there is no involvement of the appellant number 2 regarding the assault on the deceased, because initial case is that 2 persons assaulted the deceased. One is Bichi Naik, appellant number 1. The other is Aparti Naik, who is not an accused in this case. So far as the assault on PW13 is concerned, there is allegation in omnibus nature that all the accused assaulted. And that is exactly the 161 statement that when he looked back, he found that Bichi Naik was assaulting. Of course, he has not stated in that Aparti Naik about Aparti Naik participation. Why Aparti Naik was not charge sheeted, or he was an absconder? Okay. Then, if this is the state of affair, then what about the injuries and what is your report? You have submitted a report by that has been proved.
11.
Exhibit
11 postmortem report.
No, postmortem report we have seen.
Exhibit A is the
Certified copy. अच्छा देखियो exhibit A टा
C injured report C exhibit C. DW1 C.
Accused himself, DW1 has been examined. Okay. Let us count it.
Basically, from the evidence regarding the exit mark of the defense, whatever the A, B, C, they have marked as exhibit. Who has proved that there is nothing in the paper mark? I am not getting it.
No, it also exhibit 2. Alright. ऐसे original report. Bichi Naik DW1 हिसाब रे जो ହେଇଛି तारो I am the accused in this case on so and so I found Dasarathi was plowing my land. Dasarathi is the deceased and cutting the ridge of my land. I protested. Dasarathi abused me in obscene language, then dealt a blow by means of a spade on my head. As a result of which I sustained bleeding injury. Then again Dasarathi dealt another blow on the right arm, just below the elbow, causing bleeding injury. I then snatched away the spade from him in order to save myself, waved the spade by means of right of private defense. In the process, I lost my sense, fell down. Okay. Then I regained at Bhubaneswar Unity Port. So he has taken a right of private defense plea and examined himself, and to substantiate, he has proved the documents. Where is that? A1 पाहिलं की exhibit A1 काय बसतो तरी एवढा म्हणजे बिचिरो ଇଏ ବିଚି ହଉଛି applicant number 1 incised don't sharp cutting responsibility then inside and so on to simple the lacerated in the thin time duration and reservations.
My lord, so far the video 10 is concerned. In the cross examination, in page 60, my lord, in para 2, he has stated that I cannot say the contents of the FIR, exhibit 5. I have not gone through the contents of the FIR. The only at the instance of the IO, I sign on the report.
Which one?
My page, yeah, video 10, page 60, para 2, cross-examined by the Mayadhar.
No, this man.
And in last line, the younger brother of the injured Bhaskar asked me to report about the incident before the police. Accordingly, the FIR was drafted by the police. Man sitting in the plain cloth.
83, 84 रे हला यारो statement DW1 नो statement. DW1 is the appellant.
Bichi.
Bichi. So, original ये कहीं. I'll call initiate a proceeding against you. I have told that all the cases you should call for the original LCR. हाँ? तो मैंने ठीक से ही दो ना थी. That should have been a sealed. This is the injury report, certified copy of injury report of Bichi injury again. It was Bichi Nagai. But the exhibitor sealed a nine it. नहीं सीलटा मरा हबो सीलटा मरा हले कैन कॉपी जे माने एमान सिस्टमैटिक रे रखी ना सेटा कोन होगा କଥା ना प्रथमे मन कर चार्ज तापरे एविडेंस कॉपी रहबो प्रोसिक्यूशन विटनेसेस तापरे से जो स्टेप बाय स्टेप रहबो तापरे एक्यूज स्टेटमेंट करबो ये की लिस्ट ऑफ डिफेंस विटनेस तापरे डिफेंस एग्जिट ए टाइप रे लास्ट जज एमडी राइट तो अच्छी जीआर बट they are not send original record अच्छी होती है एगुड़ा को सब जो जेरॉक्स कला बड़े जैसे वो एयरपोर्ट सपोर्ट कर दो जाएंगे that is create from the submission of and counsel for the accused and special picking from the material available so and so is fine and that say it is not a case that no evidence acha. Hence I call upon both the accused to enter into the defense. State Defense Counsel for which he files a petition under section 323 CRC to issue process for examination of witnesses named in the petition. He also files documents as per list in support of his prayer to summon the witnesses. Copies have been served. I find that the prayer of accused Bichi Naik is to call for the GR case number 520 of 2020, which is a counter to the present case, and to prove that accused Bichi Naik sustained injury during the incident. Learned Special Public Prosecutor has no objection to this, but I find for the purpose will be solved if the documents filed, that is the order sheet dated so and so in the aforesaid GR case, FIR, charge sheet, injury report are marked without any objection from the prosecution. The Learned State Defense Counsel submits that he has no objection if the documents are marked on admission. In that case, he will not only examine accused Bichi Naik as defense witnesses. Accordingly, Exhibit A to E are marked for the accused persons. So it's clear that on admission, mark each. But now, so the first document is Exhibit A. Exhibit A FIR. So the FIR টা ଅଛି କିନ୍ତୁ এটা mark ଜଣା ପଡୁନି but এই ବିଚିର FIR ଟା ଅଛି ଏଇଗୁଡାକ ସେ ଫାଇଲ କରିଛି ସେଦିନ 15/11/2000 ହଁ just the previous day हाँ 15/11 admission is ये mark file करछि document गुडा list of documents on admission में जोटा mark is certified copy of FIR सेटा होछि एटा सीलटा मारिया था and charge sheet has also been submitted. Bhaskar and Dasarathi. To keep a final report each will. Huh?
final form.
Final form each, right? Well, luckily during investigation, a counter case. During investigation, the complainant and witnesses proved the occurrence. Injured Bichi Naik was medically examined and opined to have sustained simple injuries by sharp cutting means and had substance accused Bhaskara has been arrested on such and such date and forwarded to court on 27. Accused Dasarathi expired, deceased case. So and so. In conclusion of investigation, there being sufficient evidence against both of them, that is Dasarathi and Bhaskara, I submitted charge sheet under accusing them. Dasarathi is dead, abated the Vala. Charge sheet is 341, 447, 427, 323, 324 by 34, 3 of the SC/ST Act. Deceased nare abate karigala Dasarathi, Bhaskara nare Bhaskara is PW 13 hala. Then Bichi Naik injury report dekhouchi that he has sustained 2 incised wound, I would a lacerated wound achi mid parietal region. So that has been so 2 injuries are simple, 1 the opinion has been reserved. And jota opinion reserved thila setaro final opinion asichi seta koji sending here with so and so of injured Bichi Naik. I'm to state that injured Bichi Naik being assaulted by so and so. So please give your final opinion. I'll say final opinion dela that your reserve rota is simple. So tinta ko injury hola simple in nature. It also petition under 233 on admission ne mark hoya pe jota mark is. So Mr. Das, now your initial case is not that this surviving appellant, that is appellant number 2, assaulted the deceased. FIR story is based on the statement of PW 13, the sole eyewitness.
But so far that is concerned, my lord.
Yes.
As per the statement of the PW 10, my lord, the informant, my lord, he has stated that what of the it is written by the police IO, police staff, my lord. He has no knowledge about the contents of the affair. So at this stage, my lord, it cannot be said that whatever the PW.
No. You see, come to the
Yes,
PW 10.
my lord.
PW 10 says,
my lord,
that it was as per the version of PW
yes, my lord.
13.
I am reading again, my lord. 59, page 59, my lord.
Injured jaha kahila.
My lord, the younger brother of the injured, last 3 line, my lord.
Younger brother of the injured Bhaskara mane PW 13
my lord.
eyewitness, right?
My lord,
Asked
me to report about the incident before the police.
Yes.
Report regarding the incident, my lord. What was done that they are not in extent.
Accordingly, the
my lord,
FIR
accordingly, my lord. Now let's come to the para 2, my lord. Middle of the, my lord. From the top, that is middle of the, I cannot say. I cannot say the contents of the affair, Exhibit 5. I have not gone through the contents of the affair. Only at the instance of the IO, I sign on the report. Now, we cannot say that here that whatever he has stated or has got the information from the PW 13, that has been written in the FIR.
Okay, let us say that if that is there, then your own witness PW 13
There is a contradiction, my lord.
Is that statement is consistent? He's
Yes, madam. That's
completely
true.
totally different.
My lord,
କାରଣ ପ୍ରଥମରେ ତାର କେସ୍ ହଉଛି ଯେ ମତେ ଏମାନେ ଦି ଜଣ ଗୋଡେଇଲେ, ଅପର୍ତ୍ତି ଆଉ ମାୟାଧର ମତେ ଗୋଡେଇଲେ, ମୁଁ ଦୌଡିକିନି ପଳେଇଲି। କିଛି ସମୟ ପରେ ମୁଁ ଯେତେବେଳେ ବୁଲିକିନି ଦେଖିଲି, କେବଳ ବିଚିକୁ ମୁଁ ଦେଖିଲି ମୋର ଭାଇକୁ ସେ ବିଲରେ ପକେଇକିନି ସେ କୋଦାଳରେ ମାରୁଥିଲା ହେଲା। କିନ୍ତୁ କୋର୍ଟରେ କହୁଛି, ତାର କୋର୍ଟରେ ଷ୍ଟେଟମେଣ୍ଟ ହଉଛି ଯେ ବିଚି କଟୁରୀରେ ମାରିଲା, ଆଉ ଏଇ ଆପେଲାଣ୍ଟ ଯୋଉ ସର୍ଭାଇଭିଂ ଯୋଉ ଆପେଲାଣ୍ଟ ଅଛି ସିଏ ସ୍ପେଡ ରେ ମାଇଲା, ଯୋଉଟା କି ତାର ପ୍ରିଭିୟସ ଷ୍ଟେଟମେଣ୍ଟ ରେ ନାହିଁ, ଯୋଉଟା କି ପ୍ରମାଣ ହେଇଛି।
Because in the cross examination, my lord, in page 68, para 3, last three line, madam. All the occurrence took place on the land itself, and I was at a distance of about 5 cubits when my brother was assaulted. 3 blows were given each by the spade and the cautery on the head of my brother, about 2 inches above the leg. Page 68, my lord. Last 3 lines, my lord.
All the occurrence.
All the occurrence took place on the land itself, and I was at the distance of about 5 cubits when my brother was assaulted. Now 3 blows were given each by the spade and the cautery on the head of my brother, my lord.
ଯୋଉଟା ତ ଟୋଟାଲ କହିନି,
Exactly.
ପ୍ରିଭିୟସ ଷ୍ଟେଟମେଣ୍ଟ ନାହିଁ। ଆଉ 5 କ୍ୟୁବିଟ ଯୋଉଟା ଇଏ ପୁରା ଷ୍ଟେଟମେଣ୍ଟ ହଉଛି ତାକୁ ଗୋଡେଇଲେ ସେ ଯାଇକି ଗୋଟେ ବାଉଁଶ ଇଏରେ ପହଞ୍ଚିଲା ପରେ, you see that ବାଉଁଶ ବୁଦା କହିଲା, I ran to the land of Padmanab and after running to a distance when I turned back I saw Bichi Naik. ସେ 5 କ୍ୟୁବିଟ ରେ ରହିକି ଘଟଣା ଯୋଉ ଦେଖେଇଲା, that is not correct. That was not the previous statement.
Sir, ପୂର୍ବରୁ ସେ ଯାଇଛି only after all the accused persons
ଆମେ
had
ମଧ୍ୟ
at this spot
ଏଇଟାକୁ
Bichi
just
assaulted
to
my brother.
see what is actually his statement, we verified that 161
There is
statement.
nothing, madam.
161 statement ରେ କହୁଛି ମଧ୍ୟ, ଏଇ ଆଉଥରେ ବାହାର କଲ ସେ statement ଟା।
Cross examination, I was sitting at a distance of 10 cubits. It is 10 cubits ରେ କହିଲେ, assaulted my brothers by means of a panchana stick which was laying. Bichi.
ଏଇଟା ଦେଖନ୍ତୁ, ସମୟ ପ୍ରାୟ 9:30 ବେଳକୁ ବିଚି ନାୟକ ହାତରେ ଗୋଟେ କଟୁରୀ ଧରି ଉତ୍ତ୍ୟକ୍ତ ହୋଇ ପୁଣି ଥରେ ଆମ ବିଲକୁ ଆସି ଗାଳି କଲା। ମୁଁ ନିକଟରେ ବାଉଁଶ ଗଛ ମୂଳରୁ ଉଠି ଆସି ବିଚିକି କଣ ହେଲା ବୋଲି ପଚାରିଲି ହେଲା। ଏହି ସମୟରେ ଅପର୍ତ୍ତି ନାୟକ ଗୁପ୍ତି ଧରି ଓ ତାର ବଡ ବାପା ପୁଅ ମାୟାଧର ମାନେ ଆପେଲାଣ୍ଟ ନମ୍ବର 2 ଖାଲି ହାତରେ ଆସି ପହଞ୍ଚିଲେ। ବିଚି ମୋ ହାତ ମୋଡିଦେଲା। ମାୟାଧର କହିଲା ଯେ ୟାକୁ ନେଇକି ଚାଲ, ରାମ ସେଠ ଭଳି କରିବା। ମାୟାଧର ମୋର ମୁହଁକୁ ଗୋଟେ ବିଧା ମାରିଲା, ମୋ ମୁହଁ ଫାଟି ରକ୍ତ ବାହାରିଲା। ଏହାପରେ ଅପର୍ତ୍ତି, ଗୁପ୍ତି ଏବଂ ମାୟାଧର ତା ସାଙ୍ଗରେ ଜୀବନରେ ମାରିଦେବା ପାଇଁ ମୋତେ ଗୋଡେଇଲେ। ମୋତେ ମାନେ PW13 କୁ ଗୋଡେଇଲେ। ମୁଁ ଆମ ଉପରକୁ ଥିବା ପଦ୍ମ ନାୟକର ବିଲ ଆଡକୁ ଦୌଡିଲି। ଅପର୍ତ୍ତି ଗୁପ୍ତି ବାଜି ମୋର କପାଳରେ ଖଣ୍ଡିଆ ହୋଇଗଲା। ମୁଁ ଖଣ୍ଡେ ଦୂରକୁ ଦୌଡି ଯାଇ ଫେରି ଦେଖିଲି ଯେ ବିଚି ନାୟକ ମୋର ଭାଇ ଦାଶରଥୀକୁ ତଳେ ପକାଇଛି ଏବଂ ଭାଇ ଠାରୁ ଫାଉଡା ଛରେଇ ଭାଇର ମୁଣ୍ଡକୁ ହାଣିବାକୁ ଲାଗିଛି ହେଲା। ସୋ ସିଏ ଏଇ ଯୋଉ 5 କ୍ୟୁବିଟ ଯୋଉଟା କହୁଛନ୍ତି, that is not there. ସିଏ କହୁଛି ମତେ ପଳେଇଲି, ସିଏ ଗୋଟେ
ପଦ୍ମ ନାୟକ।
ପଦ୍ମ ନାୟକର
We'll come to this spot map, my lord. At page 89. Padma Naik plot is just adjacent to the spot.
Spot.
Padma Naik.
So one thing is that not only that your version is contradictory, PW13 is the sole eyewitness. Number two, the during course of the occurrence, the appellant number one has sustained injury.
Yes, ma'am.
So that part you are not explaining how he received the injuries.
Well,
He is stating that this occurrence has taken place when I was also assaulted. That is his defense plea. এবং ডিফেন্স প্লি କୁ corroborate କରିବା
on that
ପାଇଁ
point, I will also give a judgment, my lord. I was going through yesterday. That is regarding the injury part on the accused, not explained. That cannot be taken to. That is there, my lord. I will give it.
No, that is the in 76 Supreme Court.
My lord.
That is the first time it was 76 Supreme Court time, second volume. Lakshmi Singh or something like that. That big. As per the both the volumes, it may be in the second one. Sorry. Patina, signed by Patina. Period. Select Court, Supreme Court. Yeah. Type LAXMI. Lakshmi Singh. Mogela. ये अरे से ये था मनु पत्रड़ा भर के हाइट आज କହିଲ ଆଣିବା ପାଇଁ It is 76 Supreme Court 9. That is your voice wise 9. Yeah, it's 90. What sort of decisions you have brought for this right of private defense? How are you preparing 302 case? You have been interested to argue a 302 matter. High Court live streaming hochi apanଙ୍କର by the Honorable Supreme Court in that Lakshmi Singh case.
Madam.
You should keep it tomorrow. I will submit this.
The fact of the present case clearly fall within the four corners of either of the first two principles laid down by this judgment. In the instant case, either the accused was fully justified in purging the death of the deceased and were protected by right of private defense, or that if the prosecution does not explain the injuries on the person of the deceased, the entire prosecution case is doubtful and the genesis of the occurrence is shrouded in mystery, which is sufficient to demolish the entire prosecution case. It seems to us that in a murder case, the non-explanation of injuries sustained by the accused at about the time of occurrence or in the course of altercation is very important circumstance from which the court can draw the following inferences. Number one, that the prosecution has suppressed the genesis and the origin of the occurrence and has thus not presented the true version. Number one, the witnesses who have denied the presence of the injuries on the person of the accused are lying on a most material point and therefore their evidence is unreliable. Number three, that in a case there is a defense version which explains the injuries on the person of the accused, it is rendered probable so as to throw doubt on the prosecution case. The omission on the part of the prosecution to explain the injuries on the person of the accused assumes much greater importance where the evidence consists of interested or inimically witness, or where the defense gives a version which competes in probability with that of the prosecution case. So they have stated, they have relied upon the decision of the, and this decision is Lakshmi Singh versus State of Bihar. So LAKSHMI.
LA.
Singh. We are searching as LAXMI. That's where we are not getting it. LAKSHMI. Lakshmi Singh versus State of Bihar. And it is reported in AIR citation is AIR 1976 Supreme Court 2263. And SCC reference is 1976 4 SCC 394. They have also stated in the decision somewhere that if the injuries are minor or superficial, then that is a different fact. So here is a case where the deceased, there is the accused, appellant number 1, who is dead. He has sustained injuries on the vital part of the body. Of course, it has been opined to be simple in nature, but on the head he has sustained injuries. And he lost the FIR. He was sent for the medical examination and the case was also investigated upon, and it was found to be a true case. And this is one aspect. The second aspect is that your sole eyewitness, who is supposed to be clear, trustworthy, cogent, and the evidence should be above board, he is giving a completely different story than what he has narrated in the 161 statement.
That is correct.
So in such a situation, can it be said that the version of this PW13 is absolutely reliable and truthful, so that will place reliance on his statement and convict a person under section 302
for life
and for life imprisonment?
That's registered cost. Right. We are 520. Because the one of the in this case, in that section informant, that was registered and procedure.
यार PS केसटा मध्य if you see PS केसटा होची एटा टांगी PS केस नंबर होची 105 आंकर केसटा नंबर केते
106 106
आंकर first lodging of the FIR is सेइत पई से कहूची आमे जते बेले गलु देखिला बडकू ये थाना रे थिले से कोनी PW13 जे
आगो तो एम पहुंचले से माने आगो पहुंचले
हां And so far as that assault on the other person is concerned, PW13, but he has not been this allegation are omnibus in nature, and no sentence has been awarded for that 323. Those he was. So now, so that's all, Mr.
Miller, can you yes. The finding of the trial court?
Yes.
In page 11, para 9. Married Miller.
Yes.
The Land State Defense Council also submit that the deceased and his brother were the aggressor and it is only when the accused was assaulted first he exercised his right of private defense. He says the exhibit D, clearly proved that the deceased and his brother, Peter 13, are aggressors. But I find from the exhibit A from the FIR in GR 5 to 28 2002, the land of the infant, that is the accused persons of this case, situated in Jammu Jhola, Moja, and not in the Tutum Varapalli Moja. The Land State Defense Council submit that it was a mistake, but actually the land situated in Tutumbarapalli, Moja, and the name of the land is Jumujhola. But no such document evidence is forthcoming to prove the contents of the Land Defense Council that the name of the land is Jumunjhola and it's situated in the Tutumbali Moja. The evidence of the Bill 13 is clear that while they were walking in the land, the accused persons came upon the land, threatened to assault, and then dealt blow. But that is then if we consider the Bill 3. So, and one thing, there is some mistakes in the para 8 of the judgment, my lord. That's page 11, my lord. Middle of the portion. The IO under exhibit 16 has sent the spade seized in Tangi PSK number 105/2002 marked exhibit C and sample blood stain earth from the spot marked as exhibit D. Sample blood collected by the so and so exhibit. But exhibit B and C are the defense witnesses, my lord, that marked as exhibit A to E. So there's something.
The IU under so and so has sent the spade seized in Tangi PS case number 105 টা তো হচ্ছে এমানক marked as exhibit C, sample so and so, exhibit D so and so. So a report was lost first from the accused side. Then sent for medical examination. That is appellant number 1. Reports proved on admission. Right? Then charge sheet submitted. That was also proved. Against the deceased and PW13. Now, specific questions have been also put by the State Defense Council about the injuries. Well, where is that part?
Injuries. Injury number 1.
No.
Page 77. IO
again you come to that page number 69.
69.
So you paragraph 3 ro 4-5 line the accused Bichi was also bleeding. Injury on his right arm. The accused persons arrived at the PS and at the hospital prior to us. I saw the bandage on the hand of Bichi only at the hospital. The doctor told that Bichi would survive, and so he was admitted, and my brother was shifted to Cuttack. Bichi police station ku jaithila se kotha madhya ye admit kurchandi. Bichi hospital ku jaithila se kotha madhya admit kurchandi. Apart from that, all these documentary evidence which has been proved. And you come to paragraph number 5 also of that PW13. He admits that a case was filed by Dr. Naik against me and my deceased brother for assaulting them on the same day of the occurrence. I
I
was
was
arrested in
arrested.
that case on the strength of warrant issued after 4 to 6 months.
Very there.
Then the defense plea has been suggested also. It's not a fact that we chased Bichi. Bichi means appellant number 1. And Mayadhar. Mayadhar is the present appellant number 2. And my deceased brother assaulted Bichi on his head by means of spade, and that accused Bichi snatched away the spade from the hands of that has been DW1 Isabra examining his coach. And in order to save himself, he waved the spade. And in order to save myself, the case has been filed by Bichi Naik, subsequently reported against this one. ଆଉ cross examination by accused Mayadhar ku dekhontu jota confront heichi. It is not a fact that I did not state to the IO that accused Mayadhara with accused Bichi and Aparti caught hold of my brother. Eta was their first contradiction. Paragraph 6. And then Bichi assaulted him by cautery and Mayadhara assaulted by spade. It is not a fact, so and so. And eta already IO जरिया प्रमाण heichi. That is IO upon place kale jota paragraph number 10 re. Take down. Yes, here
for
in the
the
number. Yes.
accused statement is when they have not taken any plea regarding
No,
the
because the law is settled
matter.
that even if the defense does not take a right of private defense plea, and in a case of rape, suppose he is not taking a plea of consent, but from the materials available on record, by way of cross-examination up to the prosecution witnesses or by other documentary evidence, if the court finds that the right of private defense plea is available, then that can be taken into account. So non-taking of specific right of private defense plea in the accused statement would not be a bar for this court
for the
to entertain that. Okay. JCRLA number 86 of 2005. Appellants Bichi Naik and Mayadhar Naik faced trial in the court of Lenin ad hoc additional session judge Khurda in ST case number 29 by 252 of 2003 for offences punishable under section 341, 323, 302, read with section 34 of the Indian Penal Code on the accusation that on 23/6/2002 at 9 a.m. in the paddy field situated at Tutumbarpalli, Mauja, they wrongfully restrained Daso Sethi, bracketry hereafter the deceased, voluntarily caused hurt to Bhaskara Sitha, Daso Sitha, SITH, and voluntarily caused hurt to Bhaskara Sitha, bracketry PW13, and also committed murder of the deceased in furtherance of their common intention. The London Trial Court by judgment and order dated 23/11/2004 found the appellants guilty under section 302 by 34 of the Indian Penal Code and sentenced each of them to undergo imprisonment for life and to pay a fine of rupees 2,000 in default to undergo RI for 2 months. The prosecution case, as per the first information report lodged by Janaka Sasmal bracket PW10 before the officer in charge of Tangi police station on 23/6/2002, in short, is that on that day at about 9 a.m., while he, along with the deceased and PW13, were cultivating their land situated in Mauja Tutumbarpalli, the appellants Bichi Naik, Mayadhar Naik, Raj Naik, and Aparti Naik appellants and two others, namely Raj Naik and Aparti Naik, came there being armed with lathi, katori, gupti, and abused the deceased in filthy language. And all of them assaulted the deceased by fist and kick blows. And appellant number 1, Bichi Naik, dealt cautery blow to the deceased, and Aparti Naik also assaulted the deceased by gupti. The deceased sustained bleeding injuries after receiving the blow on the head, for which he fell down on the ground. PW13 intervened and he was also assaulted by all the accused persons. PW10 and other persons shifted the deceased to Tangi Government Hospital for treatment. But since his health condition deteriorated and there was continuous bleeding from his nose, ears, and mouth, and he was senseless. The deceased was shifted in an ambulance to SCB Medical College and Hospital, Cuttack, for treatment. On the basis of such report presented by PW10 PW16, the officer in charge of Tangi Police Station, registered Tangi PS case number 106 dated 23/6/2002 under section 341, 294, 323, 324, 326, 307, 506 by 34 of the Indian Penal Code and directed SI S.K. Biswal bracket PW15 to take up investigation of the case. PW15 during course of investigation examined the informant, came to Tangi Hospital and came to know that the deceased had been referred to SCB Medical College and Hospital, and he was taken by his relations. He visited the spot, collected sample earth and bloodstain earth from the spot and prepared seizure list exhibit 2. He searched for the appellant number 1. They searched the house of appellant number 1, Bichi Naik, and seized one cautery with wooden handle as per seizure list exhibit 3. The deceased, while undergoing treatment at Cuttack, expired and the intimation was received by PW16 from Mangalabag Police Station, and accordingly PW16 took over charge of investigation from PW15. PW16, the IO visited the spot, examined the witnesses, seized the broken stick, as per seizure list exhibit 4/1. He prepared the spot map exhibit 9, arrested the appellant number 2, Mayadhar Naik, on 27/6/2002 and forwarded him to court on 28/6/2002. He received the injury report of PW13 by exhibit 1 and further received information that the appellant number 1, Bichi Naik, was undergoing treatment at Capital Hospital, Bhubaneswar, and was discharged and was to be discharged on the same day. PW16 proceeded to Bhubaneswar, reached Capital Hospital, examined the appellant number 1, arrested him after his discharge, and produced him before the court of SDGM Khurda. He placed requisition to Tahsildar Tangi for demarcation of the disputed spot, and the Tahsildar Tangi deputed RI Tangi to demarcate the land, who prepared the sketch map exhibit 10, After the death of the deceased, one UD case was registered in Mangalabag police station, and in that UD case, the inquest was conducted. The dead body was sent for postmortem examination, and the IO bracket PW16 received the UD case records from Mangalabag police station. He also seized the bloodstained lungi and napkin of the deceased under seizure list exhibit 8. The seized cautery bracket MO4 was sent to the doctor who conducted postmortem examination along with the stick MO1 and received the opinion of the doctor. He examined some further witnesses, made a prayer in the court of learned SDGM Khurda to send the material objects to SFSL Rasulgarh for chemical examination and opinion, and on completion of investigation, he submitted charge sheet against the appellants. On such and such date under section so and so. After submission of charge sheet, the case was committed to the Court of Session, where the Learned Trial Court framed the charges. And since the appellants refuted the charges, pleaded not guilty, the sessions trial procedure was resorted to establish their guilt. In order to prove its case, the prosecution examined 17 witnesses, give a gist of the witnesses. The prosecution also proved 18 documents as exhibits, and 5 also proved 5 material objects, that is so and so, so and so. The defense plea of the appellants was that on account of civil dispute between the parties, on the date of occurrence, the deceased and PW13 chased the appellants, and the deceased assaulted appellant number 1 on his head by means of a spade, and the appellant number 1 snatched away that spade from the hands of the deceased, and in order to save himself, he waved the spade. from the, to prove the defense plea, appellant number 1 himself examined as DW1 and certified copy of the FIR which was lodged by Aparti Naik on behalf of the appellants before the officer in charge of Tangi Police Station in Tangi PS case number 105 dated 23/6/2002, charge sheet in that case, injury report of appellant number 1, requisition of final opinion of the appellant number 1 and final opinion of the appellant number 1 relating to the injury. So also the certified copy of the order dated 13/3/2003 in GR case number 520 of 2002, which corresponds to Tangi PS case number 105 of 2002, was marked as exhibits such and such A, so and so देखिए लिखते हो, है ना? The Lennon trial court, assessing the ocular as well as documentary evidence on record, came to hold that the deceased has met homicidal death, which has been proved through the evidence of the doctor, through that post-mortem report. The Lennon trial court didn't accept the defense plea and relying on the evidence of PW13, the injured, held the appellants guilty under section 302/34 of the Indian Penal Code. Miss Anima Dei, Lennon counsel appearing for the लिखी दियो तो schedule. Since it is brought to the notice of this court that appellant number 1, Vichi Naik, is dead, as per the order dated 11/1/2004, সেটা বাহার করো সে অর্ডারটা 11 সেটা হবে আচ্ছা, as per order dated 16/1/2024, an order was passed that the appeal so far as appellant number 1, Vichi Naik, is concerned stands abated. Ms. Anima Devi, Learned Counsel, appearing for the appellant number 2, argued that the evidence of the sole eyewitness to the occurrence, that is PW 13, is not trustworthy, and there are material contradictions in his evidence, and he has failed to explain how the appellant number 1 sustained injuries. And he is an accused in the counter case, in the case instituted by from the side of the appellants. And therefore, it would be very risky to accept his evidence to convict the appellant number 2 under section 302 of the Indian Penal Code. And therefore, it is a fit case where benefit of doubt should be extended in favor of the appellant number 2. Mr. Arupananda Das, learned additional government advocate, on the other hand, submitted that the presence of PW 13 being an injured witness cannot be disputed at the spot, and his evidence relating to the assault on the deceased, so also on him, is getting corroboration from the medical evidence. He further argued that though some documents have been proved from the side of the defense, and the appellant number 1 has been examined as DW1 to put forth the defense plea, but in the accused statement, no such plea has been taken, and therefore no importance is to be attached to the defense plea. And since the injuries were caused on the vital part of the body of the deceased, and as per the post-mortem report, bracket exhibit 11, the cause of death was due to craniocerebral injuries. And the injuries received by the deceased were antemortem in nature. And the doctor has opined that the seized weapons, that is cautery and wooden stick, and that the injuries were possible by the seized weapon which was sent to him, that is cautery and wooden stick. It can be said that the London trial court has rightly held the appellant number 2 guilty under section 302. by 34 of the Indian Penal Code. And even if the injury report which has been proved from the side of the defense is taken into account, since the injuries were simple in nature, the prosecution is not duty bound to explain such injuries, and therefore the appeal should be dismissed. Before adverting to the contention raised by the learned counsel for the respective parties, it is pertinent to note that the doctor who conducted post-mortem examination could not be examined during trial. However, the post-mortem report has been marked as Exhibit 11 . Exhibit list of Hargala. Exhibit 11 টা back করো। Exhibit 11 কইলি। হ্যাঁ। আরে ଯୋଉଟା ବାହାର କରୁଥିଲ ସେଗୁଡା ବାହାର କର। ଆଉ ଟିକେ back କର। And exhibit, the postmortem report has been marked without objection. The doctor has noticed the following injuries, quote kardebe, and further opined যে যেটা finding রয়েছে that his cause of death is so and so সেটা opined that. In view of the inquest report, marked as Exhibit 6, the postmortem report findings and the materials available on record, we are of the view that the London trial court has rightly come to the conclusion that the deceased met a homicidal death. The first information report, according to PW10, was lost as per the version of the injured, bracket PW13. However, in the said report, there is nothing that the appellant number 2 assaulted to the deceased. Daso Sito. It is specifically mentioned in the FIR that only 2 persons participated in the assault of the deceased, that is appellant number 1 Bichi Naik and 1 Aparti Naik. PW13 in his evidence has stated, quote कर दो बता chief examination को है ना main जोड़ा assault part है. However, it has been confronted to him and proved through the investigating officer that he has not stated that appellant number 1 assaulted the deceased with a cautery and then appellant number 2 assaulted on the backside head of the deceased with a spade. Rather, he has stated that when Aparti and Mayadhar, Aparti and appellant number 2 chased him to kill, he ran towards the land of Padmanabh, and after running to a distance, when he returned back, he saw the appellant number 1 had put the deceased on the land and assaulting on his head by snatching the spade from the deceased. Therefore, not only in the FIR, there is nothing that the appellant number 2 participated in the assault of the deceased, but also in the previous statement of PW13 before the IO, there is nothing that the appellant number 2 assaulted the deceased. From the contradictions proved, which appears to be material, it appears that the witness cannot be said to be an absolutely reliable one. Not only he is an accused in the counter case which was instituted by the appellant number 1, but also he has been charge sheeted under section so and so. From the side of the accused persons, the FIR was lodged at the first instance, and appellant number 1 was sent for medical examination on police requisition. Even PW13 has stated that the appellant number 1 was bleeding, was having bleeding injury on his right arm, and the appellants arrived at the police station and at the hospital prior to them, and that he saw the bandage on the head of the appellant number 1 at the hospital. PW13 has also admitted that a case was filed by Aparti Naik against him and the deceased for assaulting them on the same day of occurrence, and he was arrested in that case on the strength of warrant. It is correct that no such specific defense plea has been taken in the accused statement, but we find that not only the appellant number 1 has been examined as DW1 to state about the defense case, but also documents like FIR charge sheet, the injury reports of appellant number 1 have been proved from the side of the defense. And when PW 13 has not given any explanation as to how appellant number 1 has received the injuries. In the case of Lakshmi Singh versus State of Bihar, reported in AR 1976 Supreme Court 2263. The Honorable Supreme Court held that if the prosecution does not explain the injuries on the person of the accused, which was caused at about the time of occurrence or in the course of altercation, it is a very important circumstances from which the court can draw the following inferences. One, that the prosecution has suppressed the genesis and origin of the case and has thus not presented the true version. Two, that the witnesses who have denied about the presence of the injuries on the person of the accused are lying on a most material point and therefore their evidence is unreliable. Three, that in a case there is a defense version which explains the injuries on the person of the accused, it is rendered probable so as to throw doubt on the prosecution case. It is further held that the omission on the part of the prosecution to explain the injuries on the person of the accused assumes much greater importance where the evidence consists of interested or inimical witnesses, or where the defense gives a version which competes in probability with that of the prosecution case. In the case in hand, when the solitary witness, that is PW13, the evidence of the solitary witness is full of material contradictions. And even though at the first instance there was no implication against the appellant number 2 to have assaulted the deceased, which has been developed during trial, and it is proved through the investigating officers, and moreover, when the appellant number 1 has sustained injuries on the vital part of the body like his head, as appears from Exhibit C, even though the injuries have been opined to be simple in nature, but the said accused was hospitalized not only in Tangi Hospital but in Capital Hospital as stated by the investigating officer. We are of the view that it cannot be said that the version of PW13 is clear, clinching, trustworthy and above board, so that this court can place implicit reliance on his testimony to convict the appellant number 2. In view of the foregoing discussions, we are of the view that the impugned judgment and order of conviction of the appellant number under section 302/34 of the Indian Penal Code is not sustainable in the eye of law, and the same is hereby set aside. The jail criminal appeal is allowed whether this appellant is on bail or okay, the appellant is on bail granted by this court, is exonerated from the liability of his bail bonds, and the discharge, the surety bonds are cancelled. You are engaged by this court as amicus curiae.
Yes.
Okay. Put a note of appreciation on Ms. Anima Dei and Mr. Orupanand Das. 7,500 is to be paid to Ms. Anima Dei.
Beg pardon, madam. In the morning hour, I have mentioned that the father of the appellant died.
Yeah.
As per the direction, I have filed the affidavit. I saw my senior. So that
If this court
the,
then it will come. Otherwise, that it will be listed. It is in the weekly list.
my lord, today's list item 13, my lord. So that for that reason, as this code does not function, I have mentioned before.
Affidavit, they have take instruction on.
My lord.
So it can be taken up only tomorrow.
My lord, tomorrow.
That I some to say the Reliance Council has filed an affidavit. You are filing an affidavit.
My lord.
Who's affidavit?
The Advocates Club.
Affidavit wherein it is indicated that which father, the appellant is sole appellant.
Sole appellant.
Father of the appellant died today, and he has handed over the copy of the affidavit to the counsel for the state. The learning counsel for the state seeks some time to obtain instruction on the affidavit of this matter tomorrow. Which is that item?
13, madam.
Ajay Lekhiwe, that on this matter was there in the court, so and so court, as per the SI order so and so, this matter is taken. You mentioned. Then you write and bring it tomorrow. And if that court functions tomorrow, then it will be sent to that. Otherwise, it will be disturbed. Okay.
Public.
Puri BC, man, from Puri BC, my lord. I saw the copy, my lord. May it be taken up to me. I saw the copy. Item 8 within list, man.
That is item number, number item.
Item 8 within list, my lord. Item 8.
All right, we have already asked the London State Council to obtain instruction on your writ petition.
Yes, my lord. Yes, my lord.
May I beg pardon to mention, my lord, this is criminal appeal.
The applicant died in the meantime. His wife also dead. His daughter, unmarried daughter, is there. Because of the pendency of this case, the retired benefit of the appellant should not be disbursed. And may I pray the lordship kindly take it up?
There is a, have you filed that application to continue the appeal?
Yes.
394(2) that provides that has been allowed.
Substituted already.
Okay. So it's a vigilance appeal or?
It is CBI.
CBI.
And your lordship was pleased to allow the additional evidence earlier. And before this on the report. And it will take only few minutes for your lordship to take this voting.
But Mr. Naik is not present, Mr. Satak Naik.
But if it will be listed, he will.
All right, sir. Rocky.
Okay.
My lord, this criminal appeal, the IA for bail and co-accused has been released on bail, my lord.
Give it.
Yes. Particular mention, my lord, convicted in 10 years, my lord.
Yes, we will see that.
My lord, sentence has been 10 years passed by the law and trial court. Accused in custody, appellant in custody more than 7 years.
Give it.
And the several memos has been filed till not tomorrow.
Well, these bail petitions are listed, but delisted in the meantime.
Also, tied up matter for interim bail also. Thank you.
My lordship, this matter 22 January 2024 it was fixed. The matter was fixed but not enlisted, and in meanwhile the marriage is there.
It has been filed for recall of warrant of arrest, your lordship.
Recall of?
Warrant of arrest, your lordship. Because he was not present on the day to furnish the property security, lordship. That is why the NBW has been issued.
Give it.
Lordship.
My lord, it's
Just give it.
criminal appeal for I file for IA for interim bail, my lord. Tomorrow, my lord.
I want to mention that SC,
Yeah.
SC and ST.
Pardon, mention CRLA for bail and stay. Okay.
Item number 5 may be taken up next week. Item number 5.
What do you want?
Next week, your lordship.
The SC/ST matter.
Yes, your lordship.
Sufficient.
Your lordship asked to file comprehensive affidavit. I have filed.
No, notice sufficient.
Yes, notice.
You have received the case diary or nobody is there? Okay.
Item number 5.
Item number 5, case diary is available. Take down that CRLA number 1285 of 23. The land counsel for that is Kasim Khan.
Yes.
Land counsel for the appellant seeks for an adjournment of this matter. Give a date. Yes.
Item number 9. The informant has appeared today. I don't know whether Kesar is there or not, but probably he was thinking of taking some adjournment, and I don't know whether the matter will reach today or not. There is absolutely
ସେମାନେ ଆସିନାହାନ୍ତି ତ ସେ 9 ର ଯେ ଚାର୍ଜରେ କହିପାରୁନାହାନ୍ତି ଟିକେ ଅପେକ୍ଷା କରି କ୍ଲିୟର
Item 21.
Millard, in course of their argument, they have cited certain decisions before your lordship. Today I will distinguish those decisions, and tomorrow I will complete the rest of my submissions. But if your lordship recollects, first they cited 2002 5 SCC page 294.
On what point they cited that?
Introduction of a form 26 affidavit. 2002 5 SCC 294. That is Union of India versus Association for Democratic Reforms. ସେଗୁଡାକୁ ବି ଆମେ ସେଇ ଅର୍ଡରରେ ରଖିଦେଇଛୁ. My lord. My lord, the paragraph. Kindly come to paragraph 48, page 322.
Last paragraph.
Last paragraph.
Last page.
Honorable Apex Court has directed to disclose information by the candidate as enumerated under points 1 to 5.
The Election Commission is directed to call for information on affidavit by issuing necessary order in exercise of its power under Article 324 of the Constitution of India from each candidate seeking election to Parliament or a state legislature as a necessary part of his nomination paper, furnishing therein information on the following aspects in relation to his or her candidature. 1. Whether the candidate is convicted, acquitted, discharged of any criminal offence in the past, if any, whether he is punished with imprisonment or fine. Point 1 is not applicable for the respondent. 2. Prior to 6 months of filing of nomination, whether the candidate is accused in any pending case of any offence punishable with imprisonment for 2 years or more, in which charge is framed or cognizance is taken by the court of law. If so, the details are. This is applicable to you. This is applicable.
But there is no pleading in their election petition whether charge is framed and cognizance is taken.
Not only in election petition, but also in evidence.
Evidence also.
These two charges is framed and cognizance is taken in the catch-all.
Sir.
Yeah.
Now, second is 2003-4 SCC, page 399. People's Union for Civil Liberties versus Union of India. Paragraph 123.
Judgment amended 2002-5 SCC का केस है ना. On that basis, instruction है section 33 and 33B. And in this decision, 2003 for SCC 399, Honorable Apex Court declared section 33B as unconstitutional. ଆପଣ ବର୍ତ୍ତମାନ ଦେଖନ୍ତୁ page 474 ରେ ଗୋଟେ conclusions ଅଛି.
474
paragraph 123 तार point 5 and 6
last आडू page गुड़ा पे एमती उल्टा ही तो भूले दिया.
Four 475. Okay.
conclusion my lord sorry.
That they also placed on the other day.
Right.
So कानून को
5 and 6 is relevant. To conclusion कले point 1 to 9 पर्यंत 5 and 6 टा में प्लेस करिवु. Point 5 रे से declare कले कि section 33B is unconstitutional and 6 is relevant for this purpose. 33A रे से insert कले only charge has been framed. Cognizance rest को लिखले नहीं. Act itself. But point 6 रे लिखले the right to information provided for Parliament under section 33A in regard to the pending criminal cases and past involvement in such cases is reasonably adequate to safeguard the right to information vested in the voter or citizen. However, there is no good reason for excluding the pending cases in which cognizance has been taken by court from the ambit of disclosure.
ଏଇଗୁଟାକୁ ଡାଇରେକ୍ଟ କଲେ
Actual ରହିଲା କେବଳ charge has been framed. ପୁଣି ଏ କେସ୍ ରେ କହିଲେ ନାହିଁ cognizance taken ଟା ମଧ୍ୟ ଦର୍ଶାଇବ.
No, one thing, Mr. I think will not dispute that suppose against a political person, sometimes many cases are as such initiated,
ସେ
and
public cause ପାଇଁ ଧାରଣା ଦେଲେ ବି
some
case ହବ।
they might not be aware even that the case has been
Yes, sir.
instituted. So if they have been either released on bail during course of investigation,
Then there is
or
occasion to
yes, right to know, or if cognizance is taken, summons are issued or like that, they can know, and obviously charge is framed, so knowledge is there.
Fine.
But that means suppose a case has been instituted and there is no material that it was within the knowledge of the
Exactly.
person, and he has not mentioned it in that detailed list of criminal cases, that would not be a ground as
Not be a
such.
ground.
Okay. But where he is aware about the thing, he has appeared, take steps in the matter, but in spite of that,
He doesn't show.
No, not only he shows it, but what they say that he shows it wrong offenses, wrong courts, this, that. So how far that will be? Their argument is not that you have not reflected 13 cases. You have reflected, but offenses are wrongly mentioned.
Court name is
Court
wrongly
name
mentioned.
wrongly mentioned. These are the things they are harping, not that. Yes.
That will depend. In the instant case, there is no pleading by the election petitioner that respondent has not furnished information about the pending criminal cases against him in which charge has been framed or cognizance has been taken, nor there is any evidence adduced by the election petitioner to that effect.
To specifically say averment election petition ନାହିଁ that ଏଇ କେସ୍ ଗୁଡାକ cognizance ନିଆଯାଇଛି, ଏଇଟାରେ charge frame ହେଇଯାଇଛି,
That
ଏଇ
is
averment.
our
All right.
Then third case is 2014 14 SCC 189 Resurgence India.
Mr. Kanungo, you said on the other day that while you submit your note, this citations which you have placed, the relevant paragraphs you will just mention in that visa. Okay. Yeah. Yes.
Resurgence India versus Election Commission of India reported in under paragraph 29, page 203. Paragraph 29.
Right.
29.1, 29.2 place.
They relied on that 29.6.
6.
It is sum up kale, honorable.
The candidate must take the minimum effort to explicitly remark as nil or not applicable or not known in the columns and not to leave the particulars blank. That they said that. Yes.
ଏ କେସରେ କିଛି ଆମର ବ୍ଲାଙ୍କ ନାହିଁ। ରେସ୍ପଣ୍ଡେଣ୍ଟର ଆଫିଡେଭିଟରେ କିଛି ବ୍ଲାଙ୍କ ନାହିଁ।
ଆପଣ ତ ଉଡେଇ ଦେଇଛନ୍ତି ଟୋଟାଲ ସେ କହୁଛନ୍ତି
ନୋମିନେସନ ପେପର ମାଇଲର ଏଟା ହଉଛି ଫର୍ମ 26 ଆଫିଡେଭିଟ।
ଆଚ୍ଛା ଆଫିଡେଭିଟ ରେ ଆଚ୍ଛା
ଆମେ କହୁଛୁ we have fully complied.
All right.
Then Public Interest Foundation versus Union of India 2019 3 SCC 224. Paragraph 116, 117, 118. Page 280 and 281.
ସେଇଟା ବି ସେ ପ୍ଲେସ୍ କରିଥିଲେ।
ଏଥିରେ ରହୁଛି କି ମାଇଲର ଯୋଉଟା ରହିଲା କି widely publicity କରିବେ in newspaper and electronic media ରେ 116.5 ଟା ଦେଖନ୍ତୁ। The candidate as well as the political party concerned shall issue a declaration in the widely circulated newspapers in the locality about the antecedents of the candidate and also give wide publicity in the electronic media. When we say wide publicity, we mean that the same shall be done at least thrice after filing of the nomination paper. ଆମ କେସରେ ସେତେ ମଧ୍ୟ ରେସ୍ପଣ୍ଡେଣ୍ଟ କମ୍ପ୍ଲାଏ କରିଛୁ।
ତାଙ୍କର ବି ଇଲେକ୍ସନ ପିଟିସନ ରେ କୌଣସି ଆଲିଗେସନ
No, no, ସେଗୁଡା କିଛି
ନାହିଁ
ନାହିଁ।
କିମ୍ବା ଏଭିଡେନ୍ସ
ସେ ନାହିଁ ସେଗୁଡା। So far as placing in this case, what they want to say that this Honorable Supreme Court said
ତାଙ୍କର ଏଇଆ
that
lay down guideline
complete information about the criminal case ଦବାକୁ ଅଛି।
ଆଜ୍ଞା।
So when you are suppressing the offences from the public, that would amount that you have not furnished complete information. That was their submission.
Right to know is being infringed.
Right. That. All right.
ଆମର ରିପ୍ଲାଇ ହଉଛି ଏ ସମ୍ପର୍କରେ ତାଙ୍କର ସ୍ପେସିଫିକ ଆଲିଗେସନ କିଛି ନାହିଁ।
That was your case. All right.
Then Brajesh Singh versus Sunil Arora, 2021 10 SCC 241.
Right.
Paragraph 63. दिलेन ना?
हाँ दीजिए।
Paragraph 63 279.
Yes, that also they placed. Yes.
Again.
ଏଇଟା ସେଟା ତାଙ୍କର ପବ୍ଲିକେସନ କରିନଥିଲେ ବୋଲି ଅନରେବୁଲ ଆପେକ୍ସ କୋର୍ଟ କଣ୍ଟେମ୍ପ୍ଟ କରିଥିଲେ ଜନତା ଦଳ ୟୁନାଇଟେଡ ରେସ୍ପଣ୍ଡେଣ୍ଟ 3। ଏଇ କେସଟା ବି ଏଠି ଆପ୍ଲିକେବଲ।
ଆମର ରିପ୍ଲାଇ ହେଉଛି ଏ ସମ୍ପର୍କରେ ତାଙ୍କର ଆଲିଗେସନ କିଛି ପ୍ଲିଡିଂ ରେ ନାହିଁ କି ଦିସ୍ କେସ୍ ଇଜ ନଟ୍ ଆପ୍ଲିକେବଲ ଟୁ ଅସ୍ ଟୁ ଦି ଫ୍ୟାକ୍ଟସ ଆଣ୍ଡ ସର୍କମଷ୍ଟାନ୍ସେସ୍ ଅଫ ଦି ପ୍ରେଜେଣ୍ଟ କେସ୍।
ଏଇ ସେଥିରେ କୁହାଯାଇଥିଲା that the so and so are inadequate and not in consonance with the order of the Supreme Court. Tenu that is why the Honorable Supreme Court decided to initiate contempt also. Yeah.
Then contempt this matter was placed because they filed the application, the newspaper. We did not call for it. They filed the newspaper applications and relied upon the same to show that they had given correct information to the public. So we said that these newspaper cuttings also do not follow within the scope and ambit of the guidelines laid down by the Supreme Court. That is why we had cited this.
Yes.
Then, my lord, format C1 रे हमें जहाँ देइछु all 13 cases हमें देइछु
format prescribed सेटा बद्ध हैंडबुक फॉर रिटर्निंग अफसर अछि।
No, ଆପଣଙ୍କର ତାଙ୍କର କେସ୍ ଏଇଆ ନୁହେଁ ଯେ ଆପଣ ଯୋଉଟା ଆଫିଡେଭିଟ ରେ ଦେଇଛନ୍ତି ଏବଂ ପେପର ପବ୍ଲିକେସନ କରିଛନ୍ତି ତା ଭିତରେ କିଛି ଡିଫରେନ୍ସ ଅଛି ବୋଲି ସେ କହୁନାହାନ୍ତି। ଆପଣଙ୍କର ସେ କହୁଛନ୍ତି ଯୋଉଟା ମୂଳରୁ ଦେଇଛନ୍ତି that was
insufficient।
ହଁ that was 13ଟା କେସ୍ ଦେଇଛନ୍ତି ବଟ୍ ଏଇ ଯୋଉ ଯାହା କହିଲେ ଆପଣ name of the court offenses
ସେଇ ସମ୍ପର୍କରେ they should have pleaded first।
No, there is some kind of pleading that ଗୋଟେ offense 323 का 341 ଏମିତି ଗୋଟେ ଏମିତି ଅଛି କେତେଟା କେସ୍ ରେ
ସେଥିରେ ଦିଟା ପ୍ରକାରର ସେ କହିବେ ଆମେ କଣ ମାନେ ଆମେ ପ୍ଲିଡିଂ କରିନୁ ବୋଲି କହିବେ ଏବଂ କହିବେ ଯେ କଣ କରିବା କଥା ସେଇଟା ପ୍ଲିଡିଂ କରିବେ।
ତାଙ୍କର ଅଛି 5II ସି ରେ ଆମେ ଅଫେନ୍ସ ଲେଖିଛୁ 5ଟା କେସ୍ ରେ 323 ଅଛି କିନ୍ତୁ ବ୍ରିଫ ଡେସ୍କ୍ରିପସନ ଯୋଉ ଲେଖା ହଉଛି 5II ଡି ରେ ସେଠି 5ଟା କେସ୍ ଜାଗାରେ ଆମେ 3ଟା
ସେଇଗୁଡା
ମାନେ ନଟ୍ ଇଟ୍ ଇଜ ନଟ୍
no ଟୋଟାଲି ସେ କହୁନାହାନ୍ତି
ତଳ ଉପର ହେଇଯାଏ
ଟୋଟାଲ ନାଇଁ ଟୋଟାଲି କହୁନାହାନ୍ତି ସେ କହିବା କଥା ଇଜ ରାଇଟ୍ ଦ୍ୟାଟ 5ଟା କେସ୍ ଯୋଗୁ 3ଟା କେସ୍ ରେ ଆପଣ ଦେଖଉଛନ୍ତି ଯୋଉଟା ଡେସ୍କ୍ରିପସନ ଅଫ ଅଫେନ୍ସ ରେ 3 cases under wrongful restraint but in fact if we count according to your that top column that
jaha hame deichu
setru jana purji 5 cases sonu question is that how far let us say gote column re apono 5टा देखैचंदी 341 next column re jodi description deikini 3टा देखौचंदी so in that way how it would affect the result of the election.
And that is 5II re only a brief description of offense. Number of charges.
Number of cases. That was the option. केतेटा केस आपनकर एची खाली हां से ऑफेंस टा देखिबा था
केवल जे लिखते जे
you have made additional thing in that
PC Act the Kalen
PC Act. PC Act, they have given an explanation that since we are not public servant, so that was their explanation.
120B ଆମେ ଦେଖେଇଛୁ 420 ଦେଖେଇଛୁ
Okay, okay. Next.
ତାପରେ 6th ହେଲା Krishnamurthy versus Shiv Kumar reported in 2015 3 SCC 467 ସେମାନେ ପ୍ଲେସ୍ କଲେ paragraph 2, 7, 8, 12, 14, 18, 78 ତା ଦେହରେ ଅଛି 78D paragraph 82, 86, 91, 94 ଆମେ ଆପଣଙ୍କ ଦୃଷ୍ଟିକି ଆଣୁଛୁ
paragraph 5 ଟା ମାନେ
ହଁ paragraph 5 ଟା ପ୍ରଥମ ଦେଖ
as page 477. In the election petition, the petitioner mentioned all the 8 cases by way of chart, जोटा कि suppress करथिला तर pleading टा केते categorizedly से कहै then my lord para 82 at page 518
please
82 my lord last 1 2 3 4 5 6 7 8 8 line from the bottom 82 do sorry la it is up to note it is up to note here that when an FIR is filed, a person filing a nomination may not be aware of lodgement of the FIR, but when cognizance is taken or charge is framed, he is definitely aware of the said situation. It is within his special knowledge. If the offences are not disclosed in entirety, the electorate remain in total darkness about such information. It can be stated with certitude that this can definitely be called antecedents for the limited purpose. That is, disclosure of information to be chosen as a representative.
So Mr. Mishra, what you say that if they would have taken averments in the or taken specific pleading there in the averment, that out of these 13 cases, these are the cases in which cognizance of offense has been taken, and so they were aware about the same. In spite of that, even though this cognizance has been taken on such and such offense, they have only shown these are the offenses. They have excluded these offenses. So that is in violation of so and so.
Right.
That type of averment has not been, pleading is not there.
then we could have get a scope
Right, a
to
scope
reply
to reply.
my lord
Right.
Evidence भी जानी
ଆଉ evidence ରେ ବି କହିନା
evidence भी जानी then my lord paragraph 86 next page from the aforesaid it is looking that free exercise of an electoral right is paramount if there is any direct or indirect interference or attempt to interfere on the part of the candidate it amounts to undue influence. Free exercise of electoral right after the recent pronouncement of this court and the amendment of the provisions are to be perceived regarding being hurt to the purity of election and probity in public life, which have their hallowedness. A voter is entitled to have an informed choice. A voter who is not satisfied with any of the candidates and has been held in UCL case can opt not to vote for any candidate. The requirement of a disclosure, especially the criminal antecedents, enables a voter to have an informed and instructed choice. If a voter is denied of the accordance of the information and deprived of the condition to be apprised of the entire gamut of criminal antecedents relating to heinous or serious offences or offences of corruption or moral turpitude, the exercise of electoral right would not be an advice to us. He will be exercising his franchise with the misinformed mind. That apart, his fundamental right to know also gets nullified. The attempt has to be perceived as creating an impediment in the mind of a voter.
No, ये जो line टा कहले से justice Mr. कानून को highlight करते these are very serious offenses like corruption, moral turpitude, एवढा का offenses. So corruption case गोटे आपण को नारे initiate maybe with the aid of 120B. You are mentioning it in one paragraph. That is in the top paragraph. I think column number C or something like that. But while what he says that the voters might not be aware that what is section 13 of the 13(1) Roman 1 of
13(2).
But once you write it in the brief description of the that it is a corruption of so and so, the voter would be more conscious. They would say, "And a corruption case rahi." So ସେଥିପାଇଁ ଆପଣ ଯଦି omit କରୁଛନ୍ତି, then according to them, it is not permissible, and that is why they placed reliance on this.
5 IIB ରେ name of the court ରହିଲା, VGN number ରହିଲା, name of the court ରହିଲା vigilance special judge vigilance so and so କଟକ or ଭୁବନେଶ୍ୱର। 5 IIC
Do
ରେ
you mean to say that in the vigilance case only corruption cases are being tried, not other cases?
prevention of
Go
corruption.
to our vigilance court, you will find that even other cases are being tried. They are because why that has been tried. Vigilance cases takes a longer time for disposal, and they have been assigned to show that they are given points that you are to dispose of this number of cases. That is why only if vigilance cases are, they will not get the disposal, and that will be an adverse entry in their CCR. So because of insufficient disposal, that is why instruction has been given that where there is no adequate number of cases, give some other cases also. Because witnesses in vigilance cases are not turning up. So that is the reason the other cases are being tried there. It's a even though it's a vigilance court, other cases are being tried.
ଦେଇଛନ୍ତି VGN number ବି ଦେଇଛନ୍ତି।
ହଁ
ଏବଂ 5 IIC ରେ 13(1)(d) and 13(1)(2) ଲେଖିଛନ୍ତି, 13(2) ଲେଖିଛନ୍ତି, କିନ୍ତୁ brief description ରେ ଲେଖି ନାହାନ୍ତି। As it is not applicable to him, it is applicable to the public servant.
All right. Yes.
91.
91 my lord more ଅଛି। The purpose of referring to the instructions of the election commission is that the affidavit shown by the candidate has to be put in public domain so that the electoral can know. If they know the half truth,
এইটা হার করଥିଲେ ସେ
half କହୁଥିଲେ। ତାର ଲାଷ୍ଟ 4 ଲାଇନ ଆମେ 5 ଲାଇନ ଦେଖୁଛନ୍ତି, ସେଇଟାକୁ ଆମେ ଦେଖଉଛେ। ଦେଖନ୍ତୁ, it is necessary 1 2 3 4 5 6 7 8 9 ninth line from the bottom. It is necessary to clarify here that if a candidate gives all particulars and despite that he secures vote, that will be an informed, advised and free exercise of right by the electorate. That is why there is a distinction between a disqualification and corrupt practice. In an election petition, it is more vital, my lord. In an election petition, the petitioner is required to assert about the cases in which the successful candidate is involved as per the rules and how there has been non-disclosure in the affidavit. Once that is established, it would amount to corrupt practice. We repeat at the cost of repetition, it has to be determined in an election petition by the election tribunal. ତେଣୁ assertion ନେବା କଥା ମଧ୍ୟ ଏ କେସରେ କହିଛନ୍ତି, ଏବଂ paragraph 5 ରେ ଦେଖିଲେ ସେ କେମିତି କ୍ଲିୟରଲି ଲେଖିଛନ୍ତି 8ଟି କେସ୍ ସପ୍ରେସ୍ କରିଛନ୍ତି, କେସ୍ ନମ୍ବର 3 କେସ୍ ଯୋଉଟା ପଢୁଛି। ତେଣୁ ତାଙ୍କର assertion ନାହିଁ କି evidence ବି ନାହିଁ।
Paragraph 94.
In this case, these the 8 cases were suppressed in that.
8 cases were suppressed.
Paragraph 5 to?
My lord.
ଆଜ୍ଞା।
अच्छा।
पूरा से चार्ट करके ଦେଇଛନ୍ତି election petition।
Yes.
94
ରେ my lord ସେ sum up କରିଛନ୍ତି, ଯୋଉଟା କି heinous serious offense, and ଏଇଟା ଆସିଥିଲା ଗୋଟେ ପଞ୍ଚାୟତ ଇଲେକ୍ସନ ରୁ 94 ପଞ୍ଚାୟତ ଇଲେକ୍ସନ ରୁ ଆସିଥିଲା ତାମିଲନାଡୁ ପଞ୍ଚାୟତ ଅନୁସାରେ ପ୍ରେସିଡେଣ୍ଟ ପୋଷ୍ଟ ପାଇଁ, ଏବଂ ସେଥିରେ ଯେମିତି ଏଥର କରପ୍ଟ ପ୍ରାକ୍ଟିସ ଆଲିଗେସନ କଲେ ଆରପି ଆକ୍ଟ ରେ my lord ଗୋଟେ କରପ୍ଟ ପ୍ରାକ୍ଟିସ ଆଲିଗେସନ ଆଣିବା ପାଇଁ ପଡିବ, ଏବଂ ସେଥିପାଇଁ ଫର୍ମ 25 ରେ ଗୋଟେ ଆଫିଡେଭିଟ ଦେବା ପାଇଁ ପଡିବ in support of the allegations with respect to corrupt practice. It is not the case of corrupt practice. ସେଥିରେ ସେ ସେଇଟାକୁ କରିକିରି RP Act କୁ ମିଶେଇକି କହିଲେ କି ଏଇଟା କରପ୍ଟ ପ୍ରାକ୍ଟିସ ରେ ଯିବ ପଞ୍ଚାୟତ ଇଲେକ୍ସନ କୁ ଡିଲ୍ କଲେ।
linking it to the RPA.
Linking it to RP Act.
Yes.
But under RP Act,
Sections
if
are
corrupt
parametric.
practice
No,
is
the
alleged,
94.5 କହିଲେ ସେଟା ସେମାନେ
ଆଗ 94.4 ଦେଖନ୍ତୁ,
ହଁ ହଁ
as the candidate has the special knowledge of the pending cases where cognizance has been taken or charges has been framed. Particularly ଦିଟାକୁ cognizance and charge କଥାଟା କହୁଛନ୍ତି ସବୁ ବାରମ୍ବାର, and there is a non-disclosure on his part, it would amount to undue influence, and therefore the election is to be declared null and void by the election tribunal under section
no no
101
Mr. এইটা ହଉଛି ordinarily it should be presumed that ଏଇଟା ଯଦି ଆସିଯିବ ତାଙ୍କର informed knowledge ଆସିଗଲା ମାନେ ତାଙ୍କର special knowledge ରେ ରହିଲା, but suppose the case is under investigation, you are taken into custody, released on bail, can you say that you have no knowledge? So that is
Now, once I have knowledge, I have to decide.
right, so that is right. So again they have stated in that 94.5 that the question is whether it affects or not will not arise in a case of
101B ରେ material affect କଥାଟା ଆସୁନି, 101D ରେ ଆସୁଛି material affect. Their case is falling under 101D, not under 101B.
ଆଉ 94.2 ର ଯୋଉ ଜିନିଷଟା କହୁଛନ୍ତି,
ଆଜ୍ଞା,
when there is non-disclosure of the offences pertaining to the areas mentioned in the preceding clause, ଏଠି ଯେମିତି ଏଠି ଆପଣ mention କରିଛନ୍ତି PC Act ଏଠି କିଛି ଦେଖେଇଲେନି, ଆଚ୍ଛା, it creates an impediment in the free exercise of the electoral right, ସେଇଟାକୁ ମଧ୍ୟ ସେ ହାର୍ପ କରୁଥିଲେ ସେଦିନ, ଯେ ଆପଣ ଖାଲି ଗୋଟେ କଲମରେ ଦେଖେଇଦେବେ PC Act କେସ୍ ଅଛି, description of offense ରେ ଲେଖେଇବେନି ମାନେ ଦେଖେଇବେନି, then it creates an impediment in the free exercise, କାରଣ ସାଧାରଣ ଲୋକ ସିଏ ଜାଣିନଥିବ ସେ offense କଣ, ତ ଏଠି ହେଲେ ସିଏ ହୁଏତ ବୁଝିଯିବ ଯେ 5ଟା କେସ୍ ମର୍ଡର ଅଛି, 4ଟା ଡକାୟତିରେ ଅଛି, ସେଠି ଲେଖିଥିବେ 395, ସିଏ କଣ ଜାଣିବ 395 IPC କଣ ହେଲା, ତ that was that they were harping on. All right, next.
But there is no pleading to that effect.
That I have noted down.
Then 7 is Kishan Shankar Kathor, Arun Dattaray Samant. 2014 SCC, page 162. ସେ ରିଲାଏ କରିଛନ୍ତି paragraph 2, 31, 32, 34, 36, 41, 42, 43.
Right. 37 you realize.
ଆମେ 2 ଟାକୁ main load ଦେଖନ୍ତୁ. The election petition was filed under section 101 DI and Agri of the Act on the ground that in the nomination form filled by the appellant, he had suppressed his dues payable to the government, suppressed the assets of his spouse, and also suppressed the information and assets of a partnership firm of which he is a partner. এই instant case ରେ এই allegations କିଛି ନାହିଁ ଯେ ଆମେ suppress କରିଛନ୍ତି respondent any assets ତାଙ୍କର ଅଛି extra ଯୋଉଟା
ସେଇଟା ନାହିଁ ଯେ ଯୋଉ ଆରଟା ଆପଣଙ୍କର
dues
ନାଇଁ suppressed the assets of the spouse, ने spouse कर जो information दिया इची correct है
खाली खाता नंबर तो
नहीं partnership part B A रे
partnership farm ऊपर भी तांकर अछि ना
partnership farm ऊपर
कौन नहीं मो
तांकर अछि allegation की जो कंपनी रो से डायरेक्टर से कंपनी huge loan nature, but the affidavit in form 26 there is no space to mention the dues of a company where the respondent is director. He has to only give.
All right, continue. Yes, next.
My lord, then paragraph 36
is
page 145, 85.
Substantial compliance.
Question tackle whether there is a substantial compliance in disclosing the requisite information in the affidavits filed by the appellant along with the nomination paper.
That has to be decided by your lordship.
43
43 टा सर देखो पेज 188
সেটা তো পুরা রিপ্লেস করছিল
आगे
I marked it, Mr.
माइनर
as there was misinformation or suppression of material information.
Yes.
Then next is Merembakam Prithviraj versus Fukrem Sarath Chandra Singh, reported in 2017 to SCC
Right.
487.
Right. They have placed reliance on
Paragraph
different
2,
paragraphs.
8, 9, 10, 13, 17, 19, 23, 26.
Yes, sir. Anything you want to say on this?
Yes.
On 19 ta my lord.
खाली 19 टा देख
499. Yes. The contention of the appellant that the declaration relating to his educational qualification in the affidavit is a clerical error cannot be accepted. It is not an error committed once. Since 2008, the appellant was making the statement that he had an MBA degree. It once say नथिला 2008 ରୁ ଯେତେ ଇଲେକ୍ସନ ସେ ଲଢୁଥିଲେ ସବୁଥିରେ MBA degree କରୁଥିଲେ. The information provided by him in the affidavit filed in Form 26 would amount to a false declaration. The said false declaration cannot be said to be a defect which is not substantial. He was given an opportunity by the returning officer to produce the relevant document. Objection hitla scrutiny bele to produce the relevant document in support of his declaration. At least at that point of time, he should have informed the returning officer that an error crept into the declaration. He did not do so. The false declaration relating to his educational qualification cannot be stated to be not of a substantial character. It is no more res integra that every candidate has to disclose his educational qualification to subserve the right to information of the voter. Having made a false declaration relating to his educational qualification, the appellant cannot be permitted to contend that the declaration is not of a substantial character. For the reasons stated supra, we uphold the findings recorded by the High Court that the false declaration relating to the educational qualification made by the appellant is substantial in nature.
ए केस रे तांकर आम एजुकेशनल क्वालिफिकेशन संपर्क रे किछि अभियोग
they wanted to show
बा
that
से
just
स्क्रूटिनी बेले भी कोनोसी
BA
objection
ଜାଗାରେ ଜଣେ MBA ଲେଖିଥିଲା ତାର
गोटाए अक्षर थिला बेले कि
how seriously it was taken by that was the reason.
से once करनथिले
And this plea was taken to be a clerical error, but that was
over. And एथिके आगे से कहउछन्ती दिथर आगे एफिडेविट रे भी भूल कइले तापरे पेपर पब्लिकेशन कले सेटा भी भूल 3 times paper publication that too after scrutiny सेथरे भी भूल सब जणे ताकरी डॉक्यूमेंट सेटा हमें कॉल फॉर भी करनु से माने प्रोड्यूस
there is our reply is there is no allegation with respect to educational qualification.
Educational qualification.
We are not raising.
Educational qualification is total तार averment ही
नहीं.
Yes, next.
Then 9th is Ganga Mishra versus Chedi Paswan. एटा मनुपात्र रो पटना हाई कोर्ट रो देचंती डेट ऑफ जजमेंट 28/7/2016
3829 दे एटा पटना लॉ जर्नल
हां
पटना लॉ जर्नल रिपोर्ट सहित PLJR आर माने रिपोर्ट सहित यस
तांकर अभियोग होची returned candidate has mentioned nil against column 5II, whereas 3 cases were pending against him, out of which in one case the returned candidate was charge sheeted under section 145 IPC, which is punishable for 2 years or more. Moreover, in that case, cognizance was taken by the competent court.
So totally criminal antecedent nil. Total non-disclosure thila.
ଆମର reply ହେଉଛି
Yes.
Our reply ହେଉଛି this case is not applicable to us because there is no allegation by the election petitioner that the respondent has suppressed any case in which charge sheet has been framed or cognizance has been taken. No pleading.
Charge has been
Charge has been framed or cognizance has been taken. Next is ଆମ ହାଇକୋର୍ଟର ଗୋଟେ ଦେଇଛନ୍ତି ଇଲେକ୍ସନ ପିଟିସନ ନମ୍ବର 20 of 2014 ସହଦେବ ଖାକା versus ଯୋଗେଶ ସିଂ, which has been relied upon by the advocate for the election petitioner is also not applicable to the present case at hand. In that case, the returned candidate Jogesh Singh had not disclosed his property, landed property, in his affidavit in Form 26.
Serial क्यों रोकना ये?
In the present case, there is no allegation in the election petition that the respondent has suppressed and not disclosed his landed property in his affidavit in Form 26. खाली कोठी खाता नंबर टा छाड़ी जाइछु ये करछु एया
सेटा भी तांको केस भी हेची इलेक्शन पिटिशन
से भी खाता नंबर देना
से भी क्रिमिनल केसेस रे कोर्ट ना भूल लिखिछंती दफा भूल लिखिछंती
Yes, next.
Next is SLP civil number 6614 of 2023 Bhimrao Vishwanath Rao Patil versus K. Madan Mohan Rao and others. In that case, there was clear suppression of criminal cases in the affidavit of the returned candidate. In the instant case at hand, there is no allegation of suppression of any particular criminal case by the respondent in his affidavit in Form 26. The aforesaid judgment relates to dismissing of election petition under Order 7, Rule 11. Se कहते Order 12, Rule 6, Sub Rule 1. से जोटा Rule 1 और Rule 6 की करिकिरी comparison करिकिरी कहले on behalf of the election petitioner are admitted on behalf of the respondent either in his written statement or in his evidence.
It's not applicable for
এটা ଆମକୁ applicable ହଉନି. Neither pleading in the election petition nor documents brought on record on behalf of the election petitioner are admitted on behalf of the respondent either in his written statement or in his evidence. Next is CORAM Kapahi and others versus Lalchand Public Charitable Trust and another 2010 4 SCC 753.
They placed reliance on paragraph number 49.
40টা
49 को सेमाने रिलाय कले
से बोधे मनुपत्रटा ଦେଇଛନ୍ତି
हाँ 49 जोटी
କିନ୍ତୁ
लिखा है
ସେଇଟା
कि
40 ଟା ହବ ଏଠି
अच्छा
ଆମର
if the provision of order 12 rule 1
combined with order 12 rule 6
all right
it becomes clear that the provision of order 12 rule 6 is wider in as much as the provision of order 12 rule 1 is limited to admission by pleading or otherwise in writing. But in order 12 rule 6, the expression or otherwise is much wider in view of the words used therein, namely admission of fact either in the pleading or otherwise, whether orally or in writing.
ଏଥିରେ ଆମର ରିପ୍ଲାଏ ହେଉଛି ସିଏ ବି ସେମିତି ଇଲେକ୍ସନ ପିଟିସନର ଯେତେବେଳେ ଓରାଲି କ୍ରସ୍ ଏକ୍ସାମିନେସନରେ ଆମେ ଯାହା ପଚାରୁଛୁ ସେ କହିଛନ୍ତି ସବୁ କରେକ୍ଟଲି ଡିସକ୍ଲୋଜ କରିଛି
ଆମେ ଏଟା କାଲି ମାଇନର ପ୍ଲେସ୍ ଆଉ this case is not an election case. This 2010 4 SCC 4753 is not an election dispute.
ତାପରେ RW2 RW3 ଦି ଜଣ ଆଡଭୋକେଟ ସେମାନେ ବି ରେସ୍ପଣ୍ଡେଣ୍ଟ ତରଫରୁ ଆସି ସାକ୍ଷୀ ଦେଇଛନ୍ତି ସେଇଟା ବି ଆଜି କାଲି ଆମେ ପ୍ଲେସ୍ କରିଦେବୁ ଆଉ ତାଙ୍କ କ୍ରସ୍ ଏକ୍ସାମିନେସନରେ ନଥିଙ୍ଗ ହାଜ ବିନ୍ ଏଲିସିଟେଡ ଟୁ discredit their trustworthiness. Then 13 is my lord. ଆପଣ ଯୋଉଟା ପଚାରିଥିଲେ ପି ନାଲାମଲ that is reported in 1999 6 SCC page 559. ପାଇଲେ ତ
ସେଟା ବୋଧେ ସାଇଟ୍ ହେଇନଥିଲା ମୁଁ ଖାଲି
ନାଇଁ ଆପଣ
ହଁ ହଁ ଆଚ୍ଛା
ସେଟାକୁ ଆମେ ଆପଣଙ୍କ ଇଏ ପାଇଁ ପ୍ଲେସ୍ କରୁଛୁ in the case at hand the respondent in his affidavit in form 26 under 5
स्टडी कोंदु से
Reference my lord,
नालामल
1999
पी नालामल वर्सेस
versus state represented by Inspector of Police. Reference ଟା ହଉଛି 1999 6 SCC 559 page
559
In the case at hand, the respondent in his affidavit in paragraph 26, form 26, under column 5IIB, has correctly mentioned that vigilance case against him are pending in Court of Special Judge Vigilance. The respondent in his affidavit in form 26 under column 5IIC against the heading sections of concerned acts, courts involved, give number of so and so, has correctly mentioned that in cases pending in the Court of the Special Judge Vigilance, section 13(1)D read with section 13(2) of the RPC Act are involved. However, in column 5II(D) against a heading brief description of offense, the respondent has not given section 13(1)D and 13(2) of the RPC Act as the sections are applicable to
criminal misconduct.
minor.
সেটা 120
But the respondent has given brief description of offense with respect to section 120B and 420.
Criminal conspiracy
Minor. ଆମେ ଦେଇଛୁ ନା
ସେଟା ଆପଣ ବି ସେଦିନ ଦେଖିଲେ କାଢିକି 120B ମେନସନ
120B ମେନସନ ଅଛି ଯୋଉ
420B ମେନସନ ହେଇଛି
ହଁ କ୍ରିମିନାଲ ମିସକଣ୍ଡକ୍ଟ ଯୋଉଟାର 13 ର ହେଡିଂ ଟା ହଉଛି
criminal misconduct by a public servant
ହଁ
as the respondent has disclosed
এইটা माने ब्रीफ डिस्क्रिप्शन ऑफेंस रे एटा लिखा हुआ था
पब्लिक सर्वेंट
हाँ क्रिमिनल मिसकंडक्ट बाय पब्लिक
पब्लिक सर्वेंट
एटा लिखा है नहीं लिखा है किंतु कॉन्स्पिरेसी लिखा है यस
Then, as respondent has disclosed all the vigilance cases in his affidavit under its column 5IIB, 5IIC, in which it has been disclosed that the vigilance cases involved section 13(1)D and 13(2) of PC Act. Therefore, non-mentioning of brief description of section 13(1)D and 13(2) of PC Act against column 5IID cannot be categorized as total non-disclosure, and the same is not defect of a substantial character. Lastly, my lord, they relied upon two decisions. Dharti Pakad Madanlal, 87 supplementary page 93, paragraph 31,
and 120 at page 120
119 and 120.
right
Now, Harishankar Jain versus Sonia Gandhi, 2001, 8 SCC, 233, paragraph 23 at page 251, and contended before your lordship. In election petition, no amendment is permissible. If your lordship looks to those two decisions, paragraph dita diya.
31 टा my lord place
31 टा ଆମେ place କରୁ
धरती पकड़
ମଦନ ଲାଲ ସେଥିରେ ଦିଟା କ୍ୟାଚୱାର୍ଡ ଅଛି. New pleas cannot be introduced beyond limitation by way of amendment. Beyond limitation, amendment is not permissible.
120 ର page ଟାର 1 2 3 4 5 6 seventh line from the bottom देखो. The amendments claimed by the appellant are not in the nature of supplying particulars. Instead, those seeks to raise new ground of challenge. Various paragraphs of the election petition which are sought to be amended do not disclose any cause of action. Therefore, it is not permissible to allow their amendment after expiry of the period of limitation.
That is why amendment was rejected in that Dharti Pakad Madan Lal case.
And in
Harishankar Jain Sonia Gandhi case रे भी ठीक से है paragraph 23.
251 number.
Let's go.
251 number page 23 number paragraph. Section 83(1) of RPA 1951 mandates that an election petition shall contain a concise statement of material facts on which the petitioner relies. By a series of decisions of this court, it is well settled that the material facts required to be stated are those facts which can be considered as material supporting the allegations made. In other words, they must be such facts as would afford a basis for the allegation made in the petition and would constitute the cause of action as understood in the Code of Civil Procedure. The expression cause of action has been compendiously defined to mean every fact which it would be necessary for the plaintiff to prove if traversed in order to support his right to the judgment of the court. Omission of a single material fact leads to an incomplete cause of action and the statement of claim becomes bad. The function of the party is to present as full a picture of the cause of action with such further information in detail as to make the opposite party understand the case you will have to meet. Judgment is dele Samant Balakrishnan Jitendra Bahadur Singh. Mere quoting the words of the section like chanting of a mantra does not amount to stating material facts. Material facts would include positive statement of facts is also positive averment of the negative fact. जोटा माय लॉर्ड धरतिले पॉजिटिव अवरमेंट ऑफ द नेगेटिव फैक्ट आमे भी प्लेस करथुले एटा if necessary.
So this that is order 6 rule 2, it says about that material facts are not evidence, and the amendment part is in
order 6 rule 17.
Order 6 rule 17. Put me at any stage of the pleading, proceeding, and so on. So you mean to say that this type of amendment, it could have been done also even after the filing of the written statement?
Yes, yes.
After
because
before produce their evidence.
Right.
We are citing a decision we have already cited.
Civil appeal number.
It is not a corrupt practice case. It is a case of 101D. এবং ସେଥିରେ 2 ବର୍ଷ ପରେ ହାଇକୋର୍ଟ ଆମେଣ୍ଡମେଣ୍ଟ କଲେ, ସୁପ୍ରିମ କୋର୍ଟ ଆଲାଉ କଲେ, ଅପହୋଲ୍ଡ କଲେ।
No, ये 17 order 6 rule 17 ने सेम किछि restriction नहीं को स्टेज रे ये करिवो, किंतु decision is that it should be before the evidence is adduced.
Before evidence,
that means after written statement is filed, there is also a scope that because they at least knew that what the respondent wants to say, that this is
stand
certified copies and they inspected those certified copies. So ସେଠି ଗୋଟେ ଚାନ୍ସ ଥିଲା ତାଙ୍କର, ସେମାନେ amendment କରି ପାରିଥାନ୍ତେ। and ଏଇଟାକୁ ଦେଖିବେ ଏଥିରେ totally non disclosure of criminal antecedents ନଥିଲା ଏ କେସଟା। ଏଇଟା ଟିକେ ମାଇନର ଟିକେ ଭଲ ଆମେ ଦେଇଥିଲୁ।
Civil appeal number 7951. Relevant paragraph.
What do you mean to say that scope of amendment of the pleading in election petition is there till the evidence is adduced from the side of the either party?
Beginning of
a
decision टा हमें place करूचु, kindly listen.
We have heard Mr. P. Vishwanath Sethi, Lord and Senior Counsel for the appellant, and Mr. Barayapani Suyodhan, Lord and Counsel for the respondent, finally at this stage is held. By way of this appeal,
where are you pressing?
Beginning.
Page 1. By way of this appeal, the appellant return candidate whose election has been called into question by the respondent number 1 by way of election petition number 1 of 2017, year 1 of 2017, before the High Court of Andhra Pradesh, seeks to question the order dated 6/12/2019 after 2 years, whereby an application for amendment of the petition has been granted. Some of necessary details, the relevant aspects to be noticed for the purpose of this appeal are that in the election petition filed by the respondent number 1 herein, essentially 2 broad grounds have been urged. One being of improper acceptance of nomination of the returned candidate, that is the appellant herein, and the second being of improper receipt of invalid votes and improper rejection of valid votes. The second ground as referred herein above to the improper acceptance of invalid
So we
vote
are
and
not concerned with that. Leave it.
the second the second referred is not relevant for the purpose of the present appeal. The relevant part of the matter herein is that in the petition as filed, the appellant has internally prayed for the following reliefs. B. Declare the acceptance of the nomination paper filed by the first respondent, the return candidate, with substantial defect in the affidavit as illegal, improper, and consequently set aside reject the same. In relation to the aforementioned relief, the election petitioner respondent number 1 has stated that the nomination paper of the appellant ought to have been rejected for being not accompanied by a proper affidavit, particularly when the verification part was not carrying the signature of the appellant. The other submissions are that the affidavit was drawn up on certain stamp papers, but one of them was not purchased in the name of the appellant and was purchased by some other person, and then the name of the appellant was inserted by erasing the name of the original purchaser. It had also been submitted that there had been certain blank spaces for which the affidavit was rendered negatory, and
Okay,
this
come
being
to that portion जोटी से जो amendment
amendment देखो एठी टोटली क्रिमिनल एंटीसीडेंट सस्पेंशन ऊपर रखले ने पिटिशन ने नथिला
अच्छा
8A रु देखंतु कोन से अमेंडमेंट करिया को चाहिले कोर्ट अलाउ करले it is submitted that as per section 33A I of the representation of the people act 1951 a candidate shall furnish the information as to whether he is accused of any offense punishable
एगुड़ा
with
किछि ओरिजिनल प्लीडिंग रे नथिला
किछि ओरिजिनल प्लीडिंग नथिला A B C से ए रे देखिले जे ए 6टा सेक्शन दफा रे तांक नारे केस अछि नेक्स्ट पेज रे माइलर 4 नंबर पेज बॉटम रे पेज अछि सेयाकू देइकरी से मार्शल कले एवं ताकू हाई कोर्ट अलाउ कले ऑनरेबल सुप्रीम कोर्ट
यस
जोटी कहले म आगे से
डिसीजंस गुडा रिलायड 33A टा करले
33A कले हां 86 गले 100 गले कृष्णमूर्ति को गले देन रूपलाल सेठी रूपलाल को डिसीजन टाको करेले
पैराग्राफ नंबर 18 that is the last but one paragraph नहीं last but one page रो बोलो
हां लास्ट बट वन पेज हां एठी से कहले जे सेक्शन 86(5) रे करप्ट प्रैक्टिस रो पर्टिकुलर देई हबो जोटा सेक्शन 87 को रेफर करचेंदी आगुरु सेतरे सीपीसी रे अमेंडमेंट अछि कहले जोटा करप्ट प्रैक्टिस एलिगेशन नाही सेटा फॉल करिवने 86(5) रे अमेंडमेंट रे applying the principles apposite to the facts of the present case with reference to the pleading already taken in this matter we are unable to find any fault in the approach of the High Court in allowing the amendment as prayed for. This is for the simple reason that the election petitioner respondent number 1 had never taken corrupt practice as a ground to challenge the election of the appellant. The grounds as noticed above have precisely been of improper acceptance of nomination form of the return candidate and improper acceptance of invalid votes as also improper rejection of valid votes. That being the position, the pleadings sought to be taken by way of amendment so as to indicate that the nomination form was not to be accepted for yet another reason, that is, for non-compliance of the statutory requirements cannot be said to be of introduction of any new cause of action or new ground of challenge. It cannot be said that the ground as sought to be pleaded does not have any foundation whatsoever in the petition as filed, or that pleading of such particulars would change the character of the election petition. That being the position, we are at one with the High Court that the amendment as prayed for was required to be allowed. 2 वर्ष परे beyond the period of limitation परे मध्य से कर पारे
ଆଉ ସେଠି ବି ତାଙ୍କର ଥିଲା improper acceptance of nomination
ଆଉ ଗୋଟେ डिसीजन ଆମେ मेलर देखैतिलु खाली आउथरे मन पकई देबी आनिनी सेटारे से आगो एविडेंस लेट कले तापर अमेंडमेंट हाई कोर्ट अलाउ करथिले
ସେଇଟାକୁ ସୁପ୍ରିମ କୋର୍ଟ ଡେପ୍ରିକେଟ କଲେ
foundation lay we have also no problem with that.
Out.
So, tomorrow you are concluding the case.
Today?
Tomorrow.
No, tomorrow we will.
And you are supposed to file your also note of submission.
Note of submission. Same time may be granted to both of us.
कारण से जो डिसीजन आपण साइड करथिले नोट ऑफ सबमिशन पई अधिका समय दिया जाई परिबो
हमें करना
नहीं मु जानिनी किए करथिले बट करिथिले जे नोट ऑफ आपण सरीबो आर्गुमेंट सेहि दिन नोट ऑफ सबमिशन देबे
एई दिन देई त हबनी दिने दि दिन रे
ओ हेला ठीक
आमे फास्ट वीक भीतर देई देबो
आपण काली दी जन जा कहिबे को दिन गोटे
आगे
बोली मु डेट मेंशन करी
कॉम्प्रिहेंसिवली दे हबने माइलर जते कहिजु
कने ए जो गुडा अपनी साइट करिया
It's all right, but that should be one day on consensus of both the parties. Letting mu कर देबी
सर
so you know हाँ
गोटे डेट फिक्स
काली
हाँ गोटे डेट काली फिक्स अप होबो जे only for the filing of
written
note of argument or citation is if any was that's all
that's
written your so tomorrow at 2 o'clock
fine
Supplemental list item number 1.
The petitioner is in jail custody since 9/10/2023, my lord.
what about that notice
His lordship, notice has been made sufficient since 9/1, your lordship.
the bail matter bail matter
Lordship.
it was earlier rejected or first time it was
First time.
so what is the date of custody
9/10/2023, my lord.
charge sheet submitted
Yes, ma'am.
what are the offenses
Then, my lord, 341, 143.
just go slowly 341
341, 143, 147, 148, 323, 326, 307, 294, 503.
just 307
294, 506, 120B, 149, read with section 25 and 26 of the Arms Act, read with section 31R, 31S, 32B, BA, SC/ST.
so how many injured persons are there
2, your lordship.
2, my
what are the names of those injured
lord. One, Lakhan Sahu and Jagannath Karn.
Lakhan Sahu out again
Jagannath Karn.
is a case of only accused or other persons
Other persons are there.
so
He
what
stands same footing like that of Punnu Satya Mahanti because both of them use gun injury. In
one of them has been released on bail
yes, my lord. Paragraph page 2, last paragraph. Lord Counsel for the appellant submitted that the appellant is in jail custody in 27/9/2023, and he has been charge sheeted such and such. He further submitted that the co-accused persons have already been released on bail, though the injured sustained number of injury, but only one injury is possible by firearm, which is stated to have been caused by the appellant. However, it is also the case of the prosecution that co-accused S.K.MISHRA also fired gunshot at the injured, and therefore the prosecution is not sure as to by whose firearm the said injury was caused to the injured on the left leg. Though it has been opined to be grievous in nature. Therefore, the bail application of the appellant may be considered. On that ground, my lord, the allegation was that Punu Mahanti and S.K.MISHRA
Fired
fired.
gunshot at that injured.
Yes, only allegation.
What do you say, Mr. Mishra?
Lords, the statement of the victim, that is Jagannath Karna, who sustained gunshot injury, is that, my lords, firstly is that this present accused Rinkesh Mishra, he initiated the whole assault, your lordship. After that, your lordship, he has specifically stated that on the command of the other accused who has been released on bail, this accused person first shot a bullet to his thigh, my lords. Then he attempted to shoot his chest, but somehow he came forward and managed to block that, your lordship. That is the allegations against this particular accused, my lord. He has not stated anything about the other accused shooting him. He has only said that on the direction of the other accused person, this accused person fired the shot.
No, maybe that some other person has stated that ye bhi bandhuka dhartela boli yakur
Yes,
bail
he was three accused persons were equipped with firearms.
that is right. And by the way, only one gunshot injury was there. That was on the leg. That is mentioned. I have mentioned in that
Right thigh,
right
your lord,
thigh.
my
Yes.
lords.
Or right leg. Left leg. Left leg.
Left thigh. Sorry, my lords.
All right. Considering the submission made by the learned counsel for the state submits that notice on the informant has been made sufficient on 9/1/2024. Non-appears for the informant. Land counsel for the petitioner submitted that the petitioner is in judicial custody since 9/10/2023, and he has been charge sheeted under section so and so. And similarly situated co-accused persons have been released on bail in so and so case. And he has produced the bail order copy of co-accused Satya Ketan Mahanti alias Punu Mahanti, passed in CRLA number 1102 of 2023. And argued that बाकी सेटा देखिए लिखिए जो उड़ाक रही एठी जो co-accused रिंकेश अच्छी ता जगह पिटिशनर कर देबे है ना बाकी सब समान रहिबो स्टेट काउंसिल को ऑब्जेक्शन ता जहा इछि नोट करिवे से प्लेस कले बेली स्टेटमेंट जगन्नाथ कर्ण इंजुरी रिपोर्ट्स प्लेस कले रा सब रहिबो हाँ व्हाट अबाउट द क्रिमिनल एंटीसीडेंट
This criminal antecedent it actually state has given yes, first leg.
It's only one antecedent is there.
Serial number 3. Town PS case number
57.
अच्छा दी लर्निंग काउंसिल फॉर दी हाँ एटा रहिबो एठी तांकरे एटी यार वन टा खाली रहिबो वन क्रिमिनल एंटीसीडेंट लेखा है जी क्रिमिनल तार भी एंटीसीडेंट थिला और वन क्रिमिनल एंटीसीडेंट आउ एटा से दोन हांती कॉम्प्रिहेंसिव एफिडेविट दोन हांती ने पैराग्राफ टा ओमिट कर दिया जो से दौचन एफिडेविट अछि अदल दोन हां से स्टेटस टा देचन बोली एफिडेविट लिख देबे एटा थाउ चले बाकी also someone allow for
Lordship, one wrong submission I made. The notice has been made sufficient on 3/1/2020.
अच्छा
By mistake, I stated 9/1.
9/1 में 3/1 कर दो है ना आउ से कॉम्प्रिहेंसिव एफिडेविट टा फाइल कर ए जो प्रत्येक केस रो अलग अलग फाइल करछन तो प्रत्येक केस पई अलग अलग फाइल करछन तो हां 1158 comprehensive affidavit टाकू रखिए ता देरे. Have you got other copies of this 1102?
Yes.
हाँ. नहीं एटा तो बोधे सेम. अच्छा ये तीन जन अपन को तीनटा केस था.
तीनटा केस.
अच्छा एई जोटा अन्य केस रे सेमान को नार किछि एलिगेशन नहीं फायरआर्म ये करथिले बेली.
No, they were not using firearm. One assaulted with a sword, and the other one assaulted with an iron rod.
एटा उताले एटा को कन्फाइन करिवे आइटम नंबर 1 हला. नाउ कम टू आइटम नंबर 2. ये सेम केस अछि एलिगेशन टी अलग अलग कोनो एका टाइप ऑर्डर होबन. 2 नंबर टा कोन. First tell me that about the date of custody.
9/10.
Custody alone 9/1/20
9/10.
9/10/2023,
Yes.
right? Charge sheet तो हल्ला. बाकी यार ओवरटेक टा कौन.
ओवरटेक होचे आयरन रड की
आयरन रड दीटा इंजुरी काहा को मारथिला.
Yeah, Jagannath Kornap.
जगन्नाथ कर्न.
आयरन रड टू जगन्नाथ.
Assaulted to his thigh, your lordship.
It is high. हल्ला. What about CA, criminal antecedent?
Antecedent में लौट दिया.
दे दीजन.
Yes.
अच्छा. CA रो antecedent दीजन दी. Iron rod thigh रे किछि इंजुरी अछि iron
Yeah,
rod.
the femur has broken, your lordship.
अच्छा. Learned counsel for the state submits that there is grievous injury on the thigh. है ना. बाकी आओ से जो ये टा गन ये टा काटी देबे. है ना. याद रे ये होछि iron rod वाला. Now you come to the next one.
3 cases.
Sukadev.
सुखदेव मल्लिक.
The date of ये टा कहते.
9/10.
Date of custody 9/10/2023. Charge sheet तो वाला. And so bail order copy 3 टा कर दे देबे.
Right.
हाँ. And same bail order copy but 3 टा को record रखिए आपने. Then यार नारे overtake कौन अछि.
The FIR there is no specific overtake, but in the statement of Jagannath Karna, he has stated that he both खंडारे मारला.
Sword रे.
Yes.
जगन्नाथ को.
जगन्नाथ.
Who portion of the body?
से कुछ लिखी नहीं सेंती. सुखदेव मल्लिक एक खंडारे मते मारिछि.
Any injury sharp cutting weapon रो injury अछि किछि.
Lordship, injury is there.
Paste.
लिखि देबे जगन्नाथ sustained corresponding injury बोली कर लिख देबे.
Stab wound is there, your lordship.
Yes. Stab
over the lateral aspect of left thigh.
Another
incised wound also is there, your lordship, over the right hand.
It is there though.
My lords.
All right. Corresponding injury करेगा. आउ CA अच्छी तरह देले comprehensive. आउ से जो bail order 3 टा रो देले तो. हाँ.
One antecedent.
हाँ. One antecedent अछि. Yes. Next.
Item 4.
Pass over. Not pass over.
The
Item 4, your lordship, pray for some more time. We have already sent a correspondence, your lordship.
no about what about notice? Notice sufficient or not?
I'll take that instruction, my lords.
This man has filed CRLA.
Lordship.
There are 2 other cases. Okay?
My lords.
So you have not obtained the case diary.
No, case diary is there in a connected matter, your lordship.
Get it, and then what about notice?
Notice, I'll take instruction on that.
All right, next week I'm bringing it.
My lords.
Land counsel for the state submits that the agar case diary connected case rachi.
Lordship.
All right, the case diary is available in a connected case, and so far as service of notice on the informant is concerned, the matter may be taken up next week in order to obtain instruction in that respect. put up this matter in the week commencing from 5th of February 2024. The August 5/2/2024. Confirmation letter to be obtained.
Item 6.
Your Lordship, the case is registered. The case is registered.
Mr. Syed Iqbal.
Yes, sir. Barampur, from Barampur.
Yes, it's all right.
The case is registered under section 363, 366, 376, and IPC read with 6.
No, please, I'm not able to hear your voice clearly. So ask the system assistant to adjust the mic properly. Okay.
The Lordship, the case is registered under section 366.
Just wait for a moment. Notice sufficient?
Yes, brother. 11/120.
CD available?
Yes, sir.
Okay. Is it your first application or earlier rejected?
First application, Your Honor.
First application. What is the date of custody?
16th July 2023.
What are the offenses under which charge sheet submitted?
Submitted 363, 366, 376, and
Just a minute. 366,
363,
370,
6, and 376, and
363, 366,
6.
376.
363 to?
Again.
Then 366.
Brother.
Then 376 2N. Okay.
Read with 6 books of
6 of book.
my lord. With
Okay.
3, read with 3 SC/ST.
3 SC/ST Act.
What is your submission? What is the age of the victim?
Age of the victim is 16
Victim
years.
16 years, 7 months.
Victim statement is annexure 4 years.
164 statement is annexed.
Annexure 4 years.
Okay, he has stated so 4 ବର୍ଷ ହେଲା ଜାଣିଛି ଆମେ ପରସ୍ପରକୁ ଭଲ ପାଉ ମାର୍ଚ୍ଚ 17 ଦିନ ମୋର ଘର ଲୋକ ମୋର ବାହାଘର ଅନ୍ୟ ଜାଗାରେ ଠିକ କରିଦେବାରୁ ମୁଁ ତାକୁ କୁଆଡ଼େ ପଳେଇବା ପାଇଁ କହିଲି ପ୍ରଥମେ ଜାମ୍ମୁ କାଶ୍ମୀର ଗଲୁ ସେଠୁ ହାଇଦ୍ରାବାଦ ଆସିଲୁ ସେଠି ମନ୍ଦିରରେ ବାହାରିଲୁ ମୋ ଇଚ୍ଛାରେ ମୁଁ ତାଙ୍କ ସହିତ What happened to the girl, whether she is pregnant or
no?
Mr. Tripathi?
That instruction.
No. Medical examination report
Item 7.
May please the lordship, madam.
What are these defects, Mr. Mishra? 5D means state copy.
Yes.
You have removed the defects.
State copy is with us.
Okay, then was title, okay, translated copy in Oriya, next year, all these things, okay. Notice sufficient.
No, my lord.
Yes, yes.
In this case,
somebody has entered
Again, Mr. Jay Panda is appeared.
So you have received the case diary?
No, my lord. This case diary is available in another record. I ascertained today, my lord. Let it taken up next week. I will take that.
Another 2 matters are there. May taken together, my.
You are connected, madam?
Yes. To another
Give
two.
the number.
1286 and 1287.
87 both CD actually.
The number dira TPN. The London Council for the State submitted that the case diary is available in a connected case record and the matter may be taken off next week. Land Council for the appellant submit and the notice is notice to अच्छे से enter कर दें. Land Council for the appellant submitted that CRLA number so and so are connected to this CRLA and the matter may be listed together. In view of such submission, put up this matter along with CRLA number so and so, we commencing from 5th February 2024. Yes.
Obliged.
Item 8.
Notice was issued.
CD available?
Yes, sir.
And London Singer before starts, I had already appeared in behalf of the respondent number 2, but only notice has been served to me except the appeal memo.
You have not received that copy?
No, madam. Only the notice and the order of
Will take up this matter tomorrow. Mr. Mishra, please hand over a copy to him.
Yes, ma'am.
Put up this matter tomorrow. Mr. Mishra, Land Council for the appellant shall serve a copy of the appeal memo. Land Council for the informant during course of the day. Okay. But I get type ये करे तो मुझे signature नहीं है.
Item 10.
May I please your lordship?
Yes, somebody has entered. Mr.
My
Panda
lord,
is.
my lord.
Okay. CD available?
No, my lord, CD is not available.
कितना date है
Second date.
Second. Get it next week.
Yes, sir.
Land Council for the state seeks some further time to obtain the case diary. Put up this matter on 5th of February 2024. Yes, next.
Item 11.
Yeah.
Item 14.
May I please, Your Lordship?
Yeah.
The 3AC matter, my lord, notice was issued.
Today we serve the notice, man.
Okay, Mr. Roy, today the notice has been served, so we have to give some time to the informant.
My lord, my lord.
Counsel for the state submitted that notice has been made sufficient on the respondent number 2 today. In order to give time to the respondent number 2 to engage any counsel, if sort of see na he respondent number 2 ta. He, if she wants to engage any counsel, place this matter in the week. He.
Male person.
Put up this matter in the week commencing from 12th of February 2020. Hello? You have received the case diary?
No, ma'am.
CDB obtained in the meantime. All right.
506 के matter, my lord, ଟିକେ ଆଗରୁ 506 ଦଫା
ଗୋଟେ ସପ୍ତାହ ନଦେଲେ ଆଜି ସର୍ଭ ହେଇଛି ନା ସେ ଆସିବେ ଏଠି ଏନଗେଜ କରିବେ ସେନୁ ପାଇଲେନି ଟାଇମ ଓକାଲତ ନାମ ଫାଇଲ କରିଦଉଥିବେ ଟ୍ୟାଗ ହଉନଥିବ so these are the problems. So, yes, next.
Item 15.
Please, Your Lordship.
Yeah. service of notice on the respondent number 2. So also the case diary. Put up this matter on 5/2/2024. Yes.
Oblige.
Item 18.
Item 18, my lord. The last occasion, the state was instructed to get the case diary. My lord, the charge sheet was...
SC bail matter.
Yes, my lord.
Yes. Notice sufficient.
Notice confirmation letter not received, but CD received.
What is the offense here?
376 2N and
Okay.
3 SST.
Get it that later. We'll
Yes,
take
ma'am.
up this matter next week. Land Council 164 you have got the
Yes.
Land Council for the state submit that though he has received the case diary, but he is yet to receive the confirmation letter regarding service of notice on the respondent number 2. Put up this matter on 5/2/2024. Instruction regarding service of notice be obtained in the meantime. Next week as well.
Obliged, my lord.
Item 19. My lord, I pray for an adjournment for item number 19.
You are for the
Opposite party number 1, my lord.
what is this matter?
My lord, this appeal is directed against the order of the learned additional session judge Jajpur in allowing a petition of the prosecution under section 319.
Well, additional. You have been added as an accused.
Yes.
So you have received the case diary?
No, my lord. The first time it has come.
No. It's a today. Today would be the order number 5. So 4 orders have already been passed.
Our copy not served at that time.
Copy already served.
Lately served.
Okay. No. It's all right, Mr. Tripathi.
Yes, ma'am.
It is a case where he was not charge sheeted. During course of evidence, material came against him. So perhaps the petition was filed under 319 CRPC by the prosecutor, and accordingly it was allowed, and he has challenged that order. So he is supposed to give you the copy which he has given, and
here state is not a party, my lord.
Why?
State is a party.
State is a party. Opposite
State
party
is a
number
party.
2.
I have supplied the entire copy of the
The opposite party number 2 is state. Maybe that
item 19.
State of Orissa ଅଛି ପୁରା number 2 ନାହିଁ କଣ କହୁଛନ୍ତି?
Yes, ma'am. The CD will...
And 3 SC matter, it's a PS case ରୁ arise କରିଛି. ଆପଣ party necessary party ଆପଣ ନାହିଁ କରୁଛନ୍ତି କଣ? FIR ଦେଇଛନ୍ତି, annexure 1 ଦେଇଛନ୍ତି, and so how many witnesses have been examined?
My lord, 5 witnesses have been examined.
Have you given the deposition copies?
Yes, my lord. I have served.
No, to the court you have given?
Yes, my lord.
ଦେଖିଲ court deposition copy ଅଛି? Flag A? F? Acha, okay.
State
Mr. You have got the evidence copy?
Yes, ma'am.
Because that is to be assessed whether any evidence has come or not, and
yes,
those principles are to be kept in mind, that is an extraordinary one and compelling reasons are there. All those things are to be taken into account. So you want adjournment?
Yes, my lord.
What is the period? Because you are the informant, you must be interested to...
Actually, my lord, my senior Blake is in another court, so he prayed for an Passover. So the time is running, so Passover is not possible, for which I'm praying for an adjournment for any date, my lord.
Right, learn counsel for the opposite party, respondent number 1, 6 for an adjournment. Learn counsel for the state submits that he has received the copy of the appeal memo along with the deposition copies as per the order dated 16/1/2024. Put up this matter in the week commencing from 12th February 2024. Interim order passed earlier shall continue till the next date. Hello?
Pledged, your lordship. Item 20.
20 is it should be extended.